All right, everybody. So, as you can see, we are live. And no, I'm not Salivate Metals. I just love that guy's show. So,
Hooah!
yeah, hey, Dick. So, everybody, I am attorney Michael Ehline. As you know, I'm a natural law rights attorney. And I've got a really cool show for you today. As you can see, you don't see my video image or Dick's video image because I am in bed with a serious back injury and I just haven't been able to get better. Um, so that's why we're doing it this way. But just bear with me, everyone. Bear with me as I get the show queued up. I'm still trying to get everything squared away so we can have a good show. All right, so that looks good. Hey, thanks, Oven Burn. And by the way, Dick, I don't know if you can see on the right there, but there's comments of people talking. Do you see any of those comments?
Follow? No, no, don't see those. Do not see those.
Okay, well, there should be if you click around.
I don't want to lose you. I
Oh,
touch nothing.
all right, because people are going to want to ask you questions, and there's normally a chat bar on the right where you can see people talking. So because you don't see that, what I'm going to do is I'm going to click show on stream, and
Oh,
now
wait a
you
minute. I turned my phone sideways and it's so tiny, it's like 2 millimeters.
hold on.
Or
Do you still see
what?
them?
No, they're gone.
Okay, so I've done is I click show on stream because you don't know how to click the button that allows you to see the chat. So now watch.
I see it. Yeah,
But you're on your phone, right? So
correct. It's tiny.
it makes it harder for you. Okay. Well, let me see if there's a way I can make this to where you can see more stuff. Does that help at all or
No, it just shifted things. Same size.
well, yeah, okay. I don't know if we're going to be able to change this. So if you can't see the questions, it's kind of pointless. So I'll take these off the screen because I want people to be able to see everything that we're sharing with them. You know what I mean?
Right. Yeah.
All right. All right, guys. So let me just get the show started off. So as you can see, I've got Dick Heller with me of District of Columbia versus Heller, and there's an image of him in the upper right corner. And then, unfortunately, I couldn't figure out how to get that image to show up on his actual display. So what you see is DH something, but he's Dick Heller, the gun dude, and he's doing this from his phone. Dick is not a computer expert, so he's he, he prefers doing radio interviews. And since my back's all screwed up and you don't want to see me on video, we're just going to do everything with images. But just so you know, on the upper right, that is Dick Heller of District of Columbia versus Heller. And Alan Beck would have never been able to argue this case before the Supreme Court, the Wolford case, if not but for Dick's activism in pushing for Second Amendment rights for people in the communist district of Washington, D.C., where he was a security guard for federal buildings. Tell us a little bit about what you did and how this all came to be, Dick.
Oh my God. You mean you want me to quote the book in 3 minutes?
No, no, I want you to tell us about what your job was and how, as a federal security guard, when you got home, you had to lock your gun up in a container and you weren't allowed to use it for defense when you got home, even though your
Right.
job was to defend
Well,
government officials in the daytime.
well, actually, cutting through the story to that particular point, I was issued a firearm, a sidearm, a 38, to protect justices at the Supreme Court Annex. It was just the building next door from the main building. And I'm a little slow. I like to, I sort of pride myself in saying I'm man enough to admit I'm the dim bulb in the chandelier amongst all the lawyers that I work with. I
Yeah.
mean, I have lawyers that have over 100 briefs just to the Supreme Court. Uh, so compared to them, I'm proud to I'm proud to be the dim bulb in their chandelier, if you know what I mean.
Yeah.
Uh, So you surround yourself with superior people and, they'll pull you up. But then I figured it out that, I mean, in real simple terms, they give me a gun to protect the government people, but I can't own a gun to go home and protect my people in my household. And then it had to be a few weeks later, I came to the conclusion we truly did back in the early 2000s live, and maybe way before that, I just was unaware of it. We do still today live in a two-tiered society. Not, and here's the key, not unlike the old Soviet Union.
Oof, that's scary. Well, can you expand on that for us? Because a lot of my
Well,
viewers weren't even alive when there was well, if they've been to California, I guess that's as close as you could get to the Soviet Union modernly. But tell us
well,
about it, Dick.
what's interesting is Virginia is not even attached to California. It's 3,000 miles away, but California East has arrived in the state of Virginia, where they're with the new election of this Spanberger socialist,
Right.
and Karl Marx said socialist, communist, there's no difference. It's just semantics. They're slowly they have, oh my God, I think a dozen gun laws, maybe 20 gun laws on the books. I mean, that they're trying to get through the legislature, through the House of Delegates, and then the Senate. And you have to figure that somewhere there are reasonable people that will prevail in the legislature that says this is going nowhere, because if we push too hard, there's too many hellers out there, and then even the DOJ might come down on the state of Virginia, like they're coming down on DC in the AR ban,
Okay. Well,
fighting the AR ban.
gotcha. Well, just tell us a little bit about what happened. Like, so you're protecting Supreme Court justices, Dick, and but when you get home, the Soviets over in DC said you couldn't use your gun to defend your property. Is that or your person? Tell
Couldn't have a gun, remember?
You couldn't have a gun
Not,
at all. Well, tell us about how that worked out and what led you to ultimately becoming a seminal Supreme Court case with your name on it.
well, I like to say I just was one of those guys. Oh, yeah, okay. Yeah, I forget the story sometimes. I was the guy that drank beer, chased girls, and drove fast cars. And one day when I heard I was a stockbroker. I remember in 1975, the city was doing dog and pony shows. You can't have guns. Um, we're going to pass laws to outlaw firearms. So in 1975, uh, towards the last quarter, they did pass a law that would take effect in October of 1976. And as a paratrooper, I lived in the freest, safest country on the planet. I did not even own a gun. So when they passed that law, I said, I don't own a gun. I think maybe I better get up off the couch and go get me a gun. So I drove from the Soviet district to America, and in back in those days, it could be Maryland or Virginia. They were the same. Maryland was the free state still
Right.
back in 1976. So I got me a gun, and that was the first. They had the first gun law then, and it was a 3-day wait. So maybe a week wait, 3 days probably. 3 days later, I drove back to America, picked up my gun, and drove it across the frontier, or they call it the state line. And when you say that today, you can hear people gasp because, oh, good picture. People, good. Current people understand that's a big gasp because it's a federal offense. But back then, there was no law about where you could take your gun. across the state line.
Okay, so
Mhm.
Dick, let me try to push it through because we still got to do the audio. What I wanted to do is just really quickly talk about because I do want to do more. It's just that the freaking audio is like over an hour long. So really quickly, everybody. So Dick Heller was a private guard for Supreme Court justices, and Dick had a gun in order to defend government officials, and that's what he meant by two-tiered system. So give me a bunch of ones if you understand so far. And Dick is my buddy, and one of the things that really motivated me about becoming friends with Dick is he was a paratrooper and I was a US Marine. So we're both steeped in patriotism and love for America. And so Dick was not allowed because of the Soviet laws that were passed in DC, like he just discussed. And what in '79, Dick, was when that law was passed? Is that what you
Oh,
said?
75 taking effect a year later.
Okay, that you could no longer have a gun in your home unless I guess it had to be disassembled and locked up. Is
No,
that
you couldn't even have one until Scalia.
okay?
So that
So
was 30 years.
well, until you petitioned Scalia. That's what's important, everybody. So in DC, you couldn't even have a gun in your house. Where we know that they have all these welfare recipients that put Glock switches on their, criminals don't obey gun laws. Is that a fair statement, Dick?
Yeah, why would they? They're
Right.
criminals.
So you were not even allowed to have a gun in your home in DC. Now, but so you had to go to a free state to get a gun. Is that a fair statement?
Sure.
Okay. So basically, you're left in a position where you're a target because you're defending government employees. So obviously, people like Antifa could target you if they wanted to, and you would have no way to defend yourself. Is that a fair statement?
On the street, correct. And I always went home at midnight, and I always rode my bicycle instead of driving. And it's just what I like to do.
Amen, brother. And I'm the same way before my back got screwed up. So the bottom line is now you went ahead and got a gun in a free state, but how does that affect you when you're in DC if you brought it
Well,
home?
that was just before the law took effect. See,
So were you grandfathered in? Is that how it worked?
um, you had to register it, and being simple, dude, I said, why would they want to Why should I have to register? They want to know where you live. Well, why would they want to know where I live? I mean, the logical conclusion, there's only one option, and that's they want to confiscate it someday.
Interesting that you would say that, Dick, because Maduro Chavez, those communist dictators down in Venezuela,
Yeah,
one of the first things they did was take away everyone's guns. Same with communist China. Same with the
everywhere.
Bolsheviks in the Soviet Union. And then, really quick, I had to throw this out there for everybody. Give me a bunch of ones if you guys ever saw the movie Red Dawn, the first one with Charlie Sheen,
Oh,
Emilio Estevez. Throw
I'm a
some one.
one. Color me
You're a one.
one.
So give me a bunch of ones if you guys ever saw that. All right, I want to see that in the chat, please. So there was a later version. Now in the original version of that movie, the very first thing that the Cuban paratroopers did is they went to the local stores and they got the forms kept at the stores where people had where there was not necessarily a registry of guns because it's illegal in the United States to have a registry of guns because of this. But they have another form. Um, I think it's called a DROS or something like that, where there's a 10-day waiting period. And so they went in there and got that form and they went and arrested everybody in the town who had firearms. In the new movie that Epstein controlled Hollywood released, that scene was removed. And it's a great
Ooh.
movie. Yeah. So, yeah. And in fact, Dick, go ahead and ramble on about your story about what happened. So you had to register your firearm, right? And you that didn't sit right with you. So how did that lead to you ultimately becoming an American icon and hero with respect to having a Supreme Court case, DC versus Heller? Talk about
Well,
that.
yeah, back in the day, we had something called telephone books. DC was about, I don't know, about 2 inches thick. And the yellow pages, it was really neat because they had all the think tanks grouped together. So I went down the list of I don't know, maybe, oh, hell, there might have been over 100 think tanks. And I called them and I visited because in DC they have, free feed lectures every month or every week for every organization. So I got to know some organizations and I kept talking about the idea. And then over a period of time, it took like 30 years, no, 20 years, 75, 90, yeah, 20 years. Um, and I met some people, and then I met some people who knew people, and you network. And I ended up with a guy by the name of Dr. Dane von Breikenrickart, who was an Olympic shooter and a Vietnam combat vet
Right.
pilot. And he was also, Dana was also on the President's 100, which means every year there's a celebration at the White House for the top 100 shooters in America. And he was one of them. And when I met him, I was renting a place to him. And he said, "Okay, I like this place. I'm in. Here's the check. What do I do with my guns?" And so this was about 1993. And I
Right.
said, "Gun, right. We don't have guns in DC." And he says, "No, no." He says, I said, "What kind of gun do you have?" When I knew he was serious, he says, "Well, I have a trunk full of guns." And I went, "Right. Nobody has a trunk full of guns." He said, "I'm an Olympic shooter. I have a lot of guns."
Okay.
And then I started to turn white. I said, "Man, we're going to go to jail. You've got to get them out of town." And this was like about midnight. I don't know, 9 o'clock maybe. I was getting off work early that night. So 10 o'clock. And I said, "You've got to get them out of town." So he actually had a storage place in Virginia at the time. So he took his trunk full of guns and got them out of town, put them in his storage shed. And he said, "Dude," we didn't use that word back then, but he said, "I'm going to go to law school. This is not right." And in like this, it was like the same sentence. And I said, and I guess I'd been thinking about it. I said, "And I'm going to become a cop. You'll have the law. They'll give me a gun. Somehow that will give us horsepower." And
Okay.
that's what
Okay.
started it.
Okay. So basically, you guys came up with a game plan to try to reclaim your Second Amendment rights in DC. Is that a fair statement?
He went through 3 years of law school, did not want to graduate, did not walk across the stage. He said, "I just wanted to learn how to fight this idea of gun control."
Oh my God, this guy sounds like a brother from another mother with me.
Yeah,
Okay, so Dick, the bottom line is ultimately,
dude. The name's Dude.
dude, ultimately you guys ended up filing briefs that had to go all the way through the lower courts and up to the US Supreme Court. And I have to sort of make it short because we've got so much material to cover, but now that I know you're not averse to doing audio interviews, I definitely want to do another one with you where we allow you to talk as much as you want and share your whole story for posterity so my kids can remember that their father knew Dick Heller. So we're going to do that. But ultimately, what ended up happening, guys, is I just want to get through this because I want to talk about the Wolford case. But before
Yeah,
I,
you know what? I've done two fabulous. One fabulous with One American News. We did it on one take, no
yeah,
editing. It is phenomenal. I mean, it even impressed me.
all right.
I mean, God just wanged me with a magic wand or something that day, and it was a perfect take. You ought to just play that.
Well, we're gonna
It's
we're
been-
gonna well, we're gonna do an even better one because you and I are military brothers, and we're gonna be able to get into a lot more details than One American News. And trust me, it's gonna be better. By the way, guys, give me a bunch of ones for Life Under the Microscope. He just gifted a bunch of memberships to my audience, and I really appreciate that, guys. As you know, my channel had gotten banned by YouTube when I started talking about Bill Gates' safe and effective stuff, and they banned me
oh,
for misinformation that we now know since Robert Kennedy got into office was not misinformation. And so I lost about 300 paid subscribers, really hurt the channel. So Everybody, I encourage you not just to pay for super chats and all that, but to get paid subscriptions so I can start doing private shows where I do Q&A sessions with Dick Heller in the back channel, where we don't have to risk getting banned. But really quick, Dick, I wanted to say I've got the video queued up of that scene in Red Dawn, because you talked about not wanting to register your gun, right?
Yeah, refuse
Okay.
to.
Refuse to. Yeah, amen, brother. So I want to play this for you because in the modern Hollywood version, the Epstein Island, Harvey Weinstein version of this movie, Red Dawn, when I was growing up, there were still a lot of patriots, even in Hollywood. And so this scene is an iconic scene, and it explains why you didn't want to register your firearm. So I'm going to play this for the audience. Okay, Dick?
Sure.
All right, here we go.
Hemos perdido casi toda la visión de noche y solo quedan algunos proyectiles ATM que disparan de noche. Pongan sus mejores hombres en grupos de cazadores, armados con RPGs. Mantengan 100 metros entre cada grupo. Escarben trincheras y esperen hasta que ellos estén bien cerca. Tienen que saber de dónde les atacan. Luego combinen su grupo y hacia ellos. Y quiero algunos antiaéreos aquí. Estamos en esa faena. Esto es un manicomio. Ви хотите меня видеть? Да. Идите в спортивния и рабочая виките и принесите ми государственный номер 4473. Жълто яве той картотеки и имею подбора описания оружия.
Yep, that's what they do.
All right. So that's what I wanted the audience to see, is that in the modern leftist anti-American version of Red Dawn, that scene was deleted. And that is probably the single most important scene in the history of United States filmmaking, because our founding fathers never intended for the government to know who had weapons or their descriptions of what they were, because our founding fathers realized that government was the problem, not the solution, and that the government needed to be bound by the chains of the Constitution, not that the people needed to be bound by the chains of government. Is that a fair statement, Dick?
Well, one thing before I forget, you might point out is the ATF is not allowed to develop a database, but they can collect data.
Right.
They're not allowed to get a source database, but they can collect data. So the last I heard, someone reported that they've been collecting 4473s and now have a file of over 2 billion guns.
Okay, well, it's interesting that you would bring that up, because starting under Barry Soetoro, aka Barack Obama, and by the way, ATF is the acronym for Always Think Forfeiture, starting with Obama.
Right.
They would go illegally without a search warrant and correct that 4473 data. And people who owned firearms, people who made purchases of Bibles or who bought things at Bass Sporting Goods, were actually added to a list, especially military veterans, a list of potential violent extremists, because anybody that Obama disagreed with was, of course, a potential violent extremist. Even though he was buddies, he supported Antifa, these people who go and terrorize elderly people and don't understand human biology, they were okay. But people like you and I, who were military veterans, people who read a Bible, people who'd purchased firearms, with help from the ATF, were placed on a list of potential violent extremists. Were you aware of that, Dick?
Are you hearing all the static?
Yeah, that's coming from your phone, unfortunately. It sounds
actually,
like...
it only comes when you're speaking.
Oh, interesting. Because I hear it when you're talking.
Interesting.
So guys in the chat, is that static making it too difficult for you guys to follow along? Is that becoming a problem? Give me some 5x5s if it's okay, because I don't know what the solution is. because I want to
See,
keep doing.
it's silent now.
Well, it's silent when we don't talk.
Correct.
All right. Well, okay. So, anyways, guys, here's the deal. Dick Heller ended up fighting that law. It's probably Stingray. That's right. So, Dr. Sean Barry, Dick, he says that it's probably Stingray. I'm getting 5x5, so the audience is cool with it. And by the way, I want to thank East Carbon Exposed, Dr. Sean Barry, Life Under, Jody Shiloh, and Zoom with Smokey Bear 2597 for joining me today. And look, guys, if you really want to support my show, the best way to do it is to buy paid packs of paid subscriptions. And because when you do that, it will send out paid subscriptions to other patriots who might want to become part of Team MPE. And so before we start the oral arguments with Alan Beck, and Alan's listening, by the way, I just got a text. He's listening in. So Alan, I can send you a link if you want to join in, even if it's from your cell phone without video, just to be part of this group. So really quick, Dick, because I know you've got a lot to say, but we've got a limited time, and you know, and my back's really screwed up, so I want to condense everything. But let me just tell you guys how I ended up meeting Dick. All right, so Alan Beck, he works with my firm, but before he did, I had somehow or another found out about Alan because he was a 2A rights attorney, and I had to meet him. Because to me, any lawyer who volunteers their time to fight for we the people on his own dime without getting paid is somebody I want to befriend and help in any way that I can. So I ended up meeting Alan down in San Diego. We met somewhere. I think we had a couple of beers or something, and turns out that Alan was a sergeant in the Marine Corps. He was a tanker. And automatically he's a brother because I'm a Marine too. And my father was a Marine before me, a combat Marine, 2 tours in Vietnam, Dick. And he died from Agent Orange after the government lied and said that Agent Orange was non-toxic and safe and effective. It was used to remove foliage from around fire bases. And my dad was an 0848. So he was in charge of dialing in all the formulas on the cannons. And because they were short on men, sometimes he would also go out as a forward observer and help the people dial in the formulas with reconnaissance teams and infantry units to bring down holy hell on top of the enemy, NVA as well as regular Viet Cong. And so anyways, I go and I meet Alan, and we instantly hit it off. The guy was taking jujitsu and I was taking jujitsu. And before that, I'd been in judo and Muay Thai. So, you know, we're Marines, we're into martial arts, we're into the Second Amendment. So years later, Alan invites me to come out as he's arguing this machine gun case out at the 5th District. And I was lobbying Congress in DC at the time on behalf of the Cruise Ship Safety Act, which I helped co-author, or at least I helped write the law, which ultimately got sponsored by congressmen and senators. And so I go down and I get to meet Dick Heller. And to me, like, oh man, I'm meeting an icon. And Dick's like, oh, you're in the Marines? I was a paratrooper. And it was like instantly we hit it off. So that guy you see in the image, that's Dick Heller. And so that's how I met Dick Heller. And I'm, guys, give me a bunch of ones for Dick for joining me today, because he is a historic figure. And if it wasn't for the District of Columbia versus Heller and its progeny, I'm of the opinion that Alan would not have even been able to argue the Wolford case. And I believe it's one of 4 times in history that the Department of Justice joined a private citizen in arguing on behalf of the private citizen before the Supreme Court. And this is a case that Alan has basically funded out of his own pocket with some donations, because he doesn't want to be beholden to the NRA or anyone else. This is Alan's case. And so give me a bunch of ones for Alan as well, being a Marine brother and being a religious Second Amendment rights advocate, natural law advocate, because it's not even the Second Amendment that gives you the right to keep and bear arms. It is a right that comes from your creator that is memorialized in the Second Amendment. Give me a bunch of ones if you guys understand that concept, that the Bill of Rights aren't laws that are granted by the government. The Bill of Rights is a memorialization of pre-existing God-granted rights that come from our Creator, as evidenced by the Declaration of Independence. So far, do you think I'm on track, Dick?
Mike, are you using an external mic? It's getting worse. Are you next to a microwave or something that's causing that static?
No, I'm actually just here talking to you. I am using an internet connection that's wireless, and that could be one of the problems. But it sounds like the audience can hear me.
It's becoming unbearable. It's like 50% static, so you're really being almost muted.
So, guys, give me some 5x5s if you can still hear me in the sidebar there. And Dick, I'm looking at my internet and it looks good to go. Looks like there's no issues there.
It's interesting. You're saying when I talk, there's static on your end.
So it says here that you may be connected to a public Wi-Fi. One of my audience members says that. So you need to check. Everybody's saying the problem is coming from Dick's phone. So you need to make sure you're not on roaming. Because if you're on roaming, your phone's going to constantly try to connect to a public internet. Do you know how to do that?
No. I mean, this is the first time I've ever had static.
Well, yeah. But the issue is that it's going through a Wi-Fi network. And so if you look on your phone, how many bars do you have?
One.
Okay, so you've got no internet. So what you need to do is make sure that I'm going to walk you through it, okay?
Okay.
Go to settings, then go to Wi-Fi.
Settings. Wi-Fi is, Wi-Fi is my FiOS network.
Okay, do you also have it set up to where you can get Wi-Fi on your telephone?
Yeah, Wi-Fi is
like
on.
In other words, where it's not.
Maybe I should turn Wi-Fi off.
Go ahead and turn. There you go. Turn Wi-Fi off, and see if your bars improve.
I went to settings. Your static stopped. Do I still have static?
No, you're good now. So what you did is your home Wi-Fi apparently does not have good internet. So that's a good thing.
That's a good thing.
Now the deal is now your name doesn't show up on that black screen, but that's okay. There you go. Okay, it came back. So don't touch anything, Dick, because now we're good. Guys, give me some.
There's the static again.
Okay, you need to go back.
But not as bad. Not as bad.
Back.
It's like,
what are your bars?
We can live with this.
What are your bars looking like? How many bars do you have?
2.
Okay, go back to settings, go back to Wi-Fi, and make sure that it's off.
Wi-Fi is off.
Okay, so now what you might want to do is walk to an area that has a little bit better reception. Like if you move from the area that you're at, those bars may increase, right? Sometimes when you walk around, you get a little bit better connection.
Well, I'm right off my FiOS.
Well, you're not going to be using FiOS. Now you're using your built-in network that comes with your phone.
Oh, wait a minute. Where'd my receiver go?
Now you're good. Whatever you did works, so don't touch anything. That's what my audience is saying. All right?
Yeah, okay.
Don't touch anything. Don't touch anything. For whatever reason, your home Wi-Fi only had 1 bar. And now by the way, guys, look, Dick is a paratrooper from the old days. Technology is not his deal. Don't hold it against him. I had to learn this stuff because I'm a lawyer and there's so many non-personal appearances anymore. I had to learn all this stuff myself because I've got to appear before courts using technology.
The modem I can't find my modem.
You don't need your modem because now you're using your phone's built-in Wi-Fi network.
Okay. So it's
don't
coming
worry
off
about
of It's coming off of T-Mobile instead of
There you
Fios.
go. There you go, brother. Exactly. You figured it out. So give me a bunch of ones for Dick that he reverse engineered it, guys. So really quick, I just want to share this brief. And by the way, so take a look at the brief, guys, on the screen. I just got to tell you what a big deal this is. The case is Jason Wolford et al. And et al. Is the legal word and other people, basically in Latin. And one of the things that I like to do, Dick, is because I am a blue collar guy. Should I tell them the story before we start this about?
Next time,
Okay,
we
fair enough.
got to move on with Alan.
Yes, sir. Versus Ann Lopez, Attorney General of Hawaii. So this is a case, and Alan is a lawyer in Hawaii, not just California. And I'm a lawyer in California and Texas. So Alan and I sort of have a nice spread, an anti-Second Amendment state like California, and then a pro-Second Amendment state like Texas. And then Alan is fighting in two anti-Second Amendment states, Hawaii and California. And so this is a case that Alan brought on his own dime. And you can see, I'm just scrolling up. This is the official transcript. And this is the written transcript. And there's a link to this transcript. It's 139 pages in the description of this video. So if you guys want to read the video, strike that, the transcript, as I play the audio orals, you can follow along and see what justices are asking Alan questions and basically cutting him off mid-sentence when he starts winning. Because in my opinion, some of these justices, the left side of the court, were cutting him off as soon as he started making persuasive arguments. But the appearances are Alan A. Beck of San Diego and Sarah Harris, Principal Deputy Solicitor of the Department of Justice. She is one of the best attorneys that the Department of Justice has. So one of the things that sort of irks me, Dick, is that a lot of people say left-right paradigm, there's no difference. Well, no, there is. With the politicians, maybe not so much. They're all part of the Federal Reserve banking cabal. But the people that they represent, people like me and you, libertarian-minded people, we know that if Biden or Kamala Harris would have gotten more justices appointed to the Supreme Court, or they would have gotten into power, that the Department of Justice would have never been arguing this brief alongside of Alan Beck. The Department of Justice would be sitting across the aisle arguing against it. So is that a fair statement, Dick?
Oh, ask Alan. He's the expert.
Well, I couldn't ask him that because he couldn't tell us, because he's got a pending case before the Supreme Court. So the last thing he wants to do is alienate himself from the justices.
Certainly.
But right. And me also having to avoid the appearance of impropriety as a lawyer, I'm asking you as a private citizen, do you think if Kamala Harris or Joe Biden would have been president, that the Department of Justice would be arguing, standing next to Alan Beck on behalf of Second Amendment rights?
No, and as a matter of fact, if the court makeup had been different, I think we would have actually had a civil war over gun rights, because you've got whole states that are not giving up their guns.
Okay.
Like West Virginia.
Dick, it sounds like you're going back into a bad connection.
Oh, you know what happened? I just figured it out. The washing machine on my end is next to my modem, my Fios modem.
Okay, but you're not using your modem. You're using your connection on your phone. So if you can walk somewhere, if you can walk somewhere and improve those bars, you're going to be good.
Better.
Look at your phone and tell me how many bars you have.
I'm down to one bar.
Okay, so what you need to do is walk somewhere else until those bars improve.
Yeah.
Maybe even go outside. If you see 2 or 3 bars, that static's going to disappear.
I'm outside.
Okay, take a look at your bars, and as you move around, you'll probably see that you start getting a better connection.
3 bars now.
Okay, so that should help. That should help. But now, my audience says when I talk, there's no static, so it's coming from your end. And it could be, like they say, that Stingray's messing with you, Dick, because we know DC hates pro-Second Amendment rights people, right? Okay, so really quick, guys, I see Pro Se America just joined us. Pro Se America is a guy who has a CCW case in California, and he's actually built a pretty powerful channel fighting on behalf of concealed carry rights. So everybody give me a bunch of ones for Pro Se America for taking his own personal crusade and representing himself, because that's what I did before I became a lawyer. I'd gotten beaten up by a traffic cop over a parking ticket, and that led me on my journey to becoming a lawyer with no law degree or undergrad. And ultimately, it's what led me to Chile de Castro, because I love it that he fights against the police state. So give me a bunch of ones for Chile de Castro and Pro Se America. Now, Dick, how are your reception bars looking? Now it's even worse. So you've got a really bad connection, Dick. So what I'm going to do is hopefully Dick is going to find a way to get more bars on his phone. And we're just going to get right into the oral arguments. And I'm going to give you a blow by blow of what's going on with these orals and let you guys decide. Hold on a minute. All right. So that was a mistake. All right. Hold on a minute. So hopefully Dick's going to figure out a way to get a better internet connection. But in the meantime, I am going to start the oral arguments. You guys ready? Here we go.
I please the court. Bruen holds Second Amendment protects the right to publicly carry firearms. By banning people from carrying firearms on private property that is open to the public unless they first obtain affirmative permission, Hawaii has run roughshod over that constitutional right. The presumptive ban clearly implicates the Second Amendment. It's plain text because it regulates arms-bearing conduct. As such, the burden is on Hawaii to justify the presumptive ban with relevantly similar historical analogs, reflecting a national historical tradition of firearms regulation. Hawaii comes nowhere close to carrying the burden. Its presumptive ban defies a national tradition of allowing people to carry onto private property open to the public unless the owner objects. Hawaii's threshold position that this court should adopt a state-by-state community standard lacks support in this court's precedent, and Hawaii's argument the laws of the Kingdom of Hawaii should determine petitioner's Second Amendment rights is completely without merit. The presumptive ban is inconsistent with our national historical tradition of firearms regulation. Hawaii attempts to show a national tradition by relying on black codes expressly passed to discriminate against African Americans and anti-poaching laws. These types of laws are nowhere near relevantly similar. Because nothing in our nation's historical tradition begins to support Hawaii's effort to thwart the exercise of a fundamental right, Hawaii's law cannot stand.
Okay, so really quickly, guys, that's the setup, but let me explain to you what's going on. So you have the Hawaii Department of Justice hiring Barack Obama's attorney. Okay, so let me explain this to you again. Hiring Barack Obama's attorney, and the best argument that he can come up with as to why the concealed carry rights in public places like walking into a business shouldn't apply is because of discriminatory black codes that were military ordinances issued after the Civil War to make sure that black people couldn't have firearms. So the state of Hawaii is literally arguing that a racist law using Barack Obama's attorney to argue on behalf of the state of Hawaii that the black codes are a historical analog as to why people shouldn't be able to conceal carry when they walk into a Walmart or they go to a public park, for example. So that's literally the state of Hawaii's argument, that the Democrat state of Hawaii is arguing that a racist law should apply to prevent people from keeping and bearing a concealed carried firearm. Okay, so that's the setup. And I disabled Dick's audio because there was too much static. And every time, unfortunately, through Dick's speaker, the audio from the Supreme Court was creating a bunch of static, probably because his volume's up too loud. But really quickly, what I'm going to do is unmute Dick real quick. Let me just unmute him. Dick, are you still there? No, not at all, brother. But I want you to stay with me. And as you find your bars get improved as far as reception goes, you may have to walk across the street. But once you get like 3 or 4 bars, you should be able to talk. But right now, it's just pure static. It may be that you want to go ahead and log off the show and then come back when you get to a better location. Yeah. Okay, so I'm going to mute you, but if when I see you pop back up, I'll pop you back in, but you need to make sure you got reception. All right, man. So here we go, guys. I'm muting Dick right now, but that's the setup. Okay, the setup is that Barack Obama's attorney is arguing on behalf of the state of Hawaii that a racist law that wasn't even a law, it was a military ordinance passed after the Civil War to make sure by a racist Union general, by the way, saying that black people shouldn't be able to keep and bear arms. And the reason why this is important is it all starts with Dick Heller. So Heller versus DC versus Heller and its progeny, Heller versus District of Columbia, stand for the proposition that people have the right to keep and bear arms, especially in their home, for purposes of defending against overreaching government as well as people who are, because that's the history. By the way, I'm bringing Dick back in. Well, I tried to bring him back in. Hold on, let me try again. All right. So, Dick, it's still real bad reception. Still really bad reception.
Can you hear me?
No, not at all. So I'm going to put you on mute, but I want you to stay with me in the hopes that you're going to get better reception, because right now it's just me talking lawyer stuff. Okay. All right. So I've got Dick on mute for now, guys, but that's Dick Heller's picture. Let me just lay this out for you. So ultimately another case came along, the Bruen decision. And basically, to try to put it into layman's terms to help you guys understand, the law now is that in order for a state to pass a gun law, there has to be a historical analog, a historical that fits in line with the history of our country, because we're not Europe. Unlike the leftist justices, we don't argue that European laws should apply to the United States. And that the left does that all the time because they're into globalism and they want a one world government, a lot of people say. So what ended up happening is the state of Hawaii couldn't find a historical analog other than that the King Kamehameha passed laws to prevent his citizens from keeping and bearing arms prior to Hawaii becoming a state. And so they're basically trying to argue that the original King Kamehameha's laws, where he disarmed his own citizens so they couldn't revolt against him, under the guise that it was preventing missionaries and Christians from arming themselves, but it really disarmed his own people as well, that should apply. And then they found another law that after the Civil War, a racist Union general decided that the black codes, that black people shouldn't be able to keep and bear arms either on public or on private property where there was an invitation or a license to enter. And therefore, that law is a historical analog or a precedent as to why the people of Hawaii can't walk into a Walmart or the local liquor store or go to a gas station while they have their concealed carry. So the leftist government of Hawaii were forced to honor concealed carry rights, but then they said only by invitation. If they're automatically, they said automatically, if hey, Dick, can you hear me now, Dick?
No static. I turned the Bluetooth off.
Oh, perfect. It was probably your Bluetooth that was trying to connect to local networks. So now you're good. Okay, so Dick, I'm going to go ahead and just leave you there, and we don't hear static anymore. So guys, Dick Heller of DC versus Heller, the guy who made it possible, in my opinion, for Alan Beck to be arguing this case, is here in the live with us today. Google it, look it up, District of Columbia versus Heller. It's the seminal case on firearms rights. Give me a bunch of ones for Dick. And by the way, thank you, Pro Se America. I got a $2 super chat from Pro Se America, and he said, thank you for bringing attention to the tyranny. And I appreciate that, brother. And I appreciate you out there fighting for the people of Communist Fornia. And good seeing you, Phoenix Feathers. Good seeing you, Phoenix Feathers 8. Jody Shiloh, Life Under the Microscope. And thank you, Life Under, for donating those memberships. Anybody who has any questions for Dick or I, super chats go to the front of the line if you've got questions. So the bottom line is this law basically said, sure, you can get a concealed carry permit, but unless a business owner gives you express permission to come on to private property that's open to the public, you are not allowed to carry your gun there. So what did that mean? Well, basically, anywhere you went in Hawaii, pretty much, you couldn't conceal carry. And so that's what the left does. And that's why when I hear people say there's no difference between the left and the right, it makes me chuckle, because there's a huge difference. Sure, the politicians are all corrupt, but as a single issue voter, I know and Dick knows that if Kamala Harris or Sleepy Joe would have been in power right now, the Department of Justice would not be arguing a case alongside of my guy, Alan Beck, in favor of concealed carry rights. And so the main issue in Wolford is that anywhere else you go that has concealed carry rights, a business owner would put up a sign saying, no concealed carry allowed at this property. Well, the state of Hawaii turned it on its head, like California is trying to do, and said, no, it's automatically prohibited for you to walk into a business that's open to the public unless the business puts a sign out saying you're allowed to have a firearm in here. Turned it on its head. Basically, like I've said before, when the laws become so voluminous that everything is illegal, everyone is an outlaw. And that's why Benjamin Franklin made it very clear that the difference between a democracy and a republic is, in a democracy, two wolves and a sheep show up for dinner and decide what's on the menu. That's a democracy, majority rules. A republic is where two wolves and a well-armed sheep shows up to contest the vote. And so in a republic, the rights of the individual are what are important, not the rights of the majority. In fact, there's no document anywhere in the history of our country that mentions democracy other than letters back and forth and books from our founding fathers protesting against democracy, because they knew that in a democracy, a rich person like the Rockefellers or the Rothschilds could own all the news media and poison the public against the rights of we the people and pass laws to restrict our freedoms by majority rules. The Constitution and the Bill of Rights made it possible for us to say, no, you're bound by the chains of the Constitution. And as evidenced in cases like Bruen, right, there has to be basically historical evidence to show that this law is constitutional. And in this case, Alan Beck is arguing on the record that no, this is ridiculous. You're arguing for a racist black code to restrict people's right to keep and bear arms. So I just wanted to give you guys the foundation, and now we're going to get in and let Alan finish.
I welcome this court's questions.
You argue that this law prevents access to about 97% of public areas. How do you arrive at that?
And that's Justice Thomas, by the way. Let's go.
We're not arguing this specific law is banning 97%, Your Honor. The overall package of laws passed by Act 52 presumptively bans carry on 96.4%. And we arrived at that figure by having an architecture firm go through the public records of the County of Maui to determine which areas were regulated by this package of laws, Your Honor.
So that 94, I think it was 94, 97%.
96.4.
So this is the Democrat Justice Sotomayor. I believe she's a Biden appointee. Let's hear the difference.
Your Honor. Justice.
That
Strike that. Obama. Did I say Biden? Because there's not much difference. Let's go.
includes all the areas the law bans, correct?
Yes, Justice.
I understood that much of Hawaii is state parks and state property, correct?
A portion of it, yes, Justice.
Pretty sizable portion. So that 94 is over-inclusive of private property, correct?
It includes parks and beaches, yes,
All right.
Justice.
Now, and there are other areas, sensitive government areas, et cetera, correct?
That is correct, Justice.
All right. So You say that there is a constitutional right to carry a gun on private property?
Yes, Justice.
So guys, really quick, what I'm going to try and do, and I need some 5x5s because I want to scroll the oral transcript. I want to scroll the oral transcript as they're talking so you can get a blow by blow. And I'm going to have to put Dick back on mute because we're getting static again from his feedback. So, but Dick, don't go anywhere because I'm going to pop in once in a while. But really quick, guys, and Alan is incredibly smart, Johnny. He's absolutely amazing. So what I'm going to do is I want to know right now, I'm going to turn the audio on and I want to know if you guys can hear it. Okay. So give me some 5x5s if you can hear it. Did you guys just hear that? Did you just now? I played the audio. Give me some 5x5s if you just heard Justice Sotomayor say, I understand. I want to know in the sidebar right now if you heard that before I move on, because I'd like to scroll the transcript. I'd like to scroll the transcript so you guys can read who's speaking and everything like that to make it a little more easier for you. So 5x5s, you did not hear it. Unfortunately, that's too bad. Okay, well, there is a link to the transcript in the description, okay? In the description of this video. What I'd like you guys to do is to open it up so you can read, because I can't tell by all the justices who their voices are. And I see that. Thank you, Life Under the Microscope. I'm going to go back to the audio. And I kind of thought that was going to be a problem. And I'm going to go ahead and just play this bad chicken, and as Chili DeCastro would say. And what I want you to listen for is the justices that were appointed by Democrats. This was my observation. Every time Allen starts making a persuasive argument, they immediately cut him off and don't allow him to finish his argument. And they also ask a lot of leading questions to try to lead Allen into something where they can, like a gotcha question. And Allen is so good. He's so eloquent, unlike me, where I would probably lose my mind. He basically allows them to ask questions that lead to the answer that, yes, you should have the right to conceal carry. And another thing I wanted to point out is that, again, Barack Obama's lawyer is arguing on behalf of the state of Hawaii, arguing that a racist anti-black gun law is the historical basis for preventing the people of the state of Hawaii to be able to conceal carry on private property that is licentiously open to the public historically. And I want you to see that Ketanji Brown, I believe that she's an Obama appointee, no, a Biden appointee, who, when asked during the confirmation hearings, what is a woman? And she was unable to distinguish the difference between a biological woman and a biological man. So that was really disconcerting for a lot of us. And now, when she's basically, it appears as though she's supporting the concept that a racist black law against black people, should apply to keep people from keeping and bearing arms. It's very disconcerting to me as a lawyer and a natural law attorney. And I believe that any opinion that supports that would be wrongly decided. So I want you guys, give me a bunch of ones if you think that it is wrong for a racist post-Civil War law by a racist Union general, not even a law, but a military ordinance. I want you to give me a bunch of ones if you think that that should not be a historical reason for denying people of Hawaii to conceal carry a firearm on private property that is open to the public. Now I'm going to go ahead and let Sotomayor continue interrogating Allen, and I want you to listen. And by the way, if you're reading the transcript, to me, the written transcript that I've included as a link, absolutely, to me, Allen nailed this case. And I've never, ever heard anybody or read a transcript like this that acquitted someone so well. Allen acquitted himself better than anyone I've ever seen, ever, or heard, or read of any case in the history of my practicing law for over 20 years. Here we go.
With an owner's consent, express or implicit, correct?
The Second
My
Amendment.
question is very simple. Is there a constitutional right to enter private property with a gun without an owner's express or implicit consent? The answer has to be simply no. You can't enter an owner's property without their consent, correct? Express or implicit?
Correct, because that would be a trespass, Your Honor.
All right. So
Okay, so notice how Alan answered the question correctly. Private property, like someone's home, you would have to get permission from the homeowner before you carried a firearm. Notice how Justice Sotomayor doesn't distinguish between the fact that this whole case is about private property open to the public, like a business, for example, that's open to the public. Notice how that was completely ignored, but how Alan didn't stumble all over himself saying, well, no, Your Honor, this case is about private property open to the public. He correctly stated that no, that would be a trespass unless you had express or implied permission from a quote unquote private property owner, because she did not distinguish between the fact that private property open to the public is totally different. Okay. And by the way, anybody who has questions, super chats go to the front of the line. Help me build this channel back up. If you like this content, make sure to like and subscribe. Hit that notification bell. If you want me to keep doing these shows, even though it's not a video because I'm on my back with a back injury, I'll do it if I know you guys really want me to do this. So far people are unsubscribing because they're I guess they're upset about the fact that I don't want 20 million illegal aliens in this country, and that I believe that the government's primary job is to protect this country from foreign invasion. All right, let's get back on with the oral arguments.
if we start from there, then I start from the simple proposition. You want to say that there's a custom that permits you to go on private property without the owner's express consent, correct?
Yes, Your Honor.
All right. So Justice Scalia said that every statesman at the founding knew that you could not enter private property without permission. It's a trespass, correct?
It is. You're not allowed to come onto private property that where you don't have permission to go to.
All right. So if we're looking at a custom, I thought
So I'm going to clarify something with you guys, and I've got Dick back on, but I'm going to have to mute his mic again because of the static, but at least he's here. So I've got Dick Heller of District of Columbia versus Heller, the guy who started it all for us in the chat today. We had a nice interview with him at the very beginning, but you just heard basically Justice Sotomayor, I believe she's an Obama or maybe a Biden appointee, no difference, basically making an argument almost on behalf of the state of Hawaii that, well, there has to be permission to enter. You just said there's got to be permission to enter private property. And the issue is, guys, is that businesses are open to the public, and there is an implied license for you to be able to enter that property. Otherwise, it would be a trespass. But notice how she's not mentioning that, even though she knows that the whole purpose of this case has to do with being able to enter property that's open to the public historically. And so if you were CNN or you were one of these lefties, oh my gosh, I can see Dick now. Hey, Dick, I see you on video. Can you hear me?
Turn my camera on. The static goes away.
Well, we still got major audio static from you, but everybody give me a bunch of ones for Dick Heller showing up. And hopefully Dick's going to figure out how to get a better internet connection. But Dick, don't go anywhere. Just the fact that you're here means the world to me in the audience, okay? Please don't go anywhere, Dick. I've got all these people in the chat bar saying, don't let Dick leave. So once you get some better reception bars, we're going to be good, Dick. But in the meantime, keep listening and let me sort of narrate what's going on at the Supreme Court, okay?
I bet you it's because of Safari. I've never had this problem before. All the interviews.
We'll figure it out, brother. It's not a big deal because right now we don't need to have you on audio because we're just going through the actual oral arguments, and we're going to figure this out, brother. And look, this is a one-off, guys. Dick is not a computer tech guy, but I need him here just for the spiritual support. Because if it wasn't for him, in my opinion, Alan would have never been able to make these arguments. But let's go ahead and listen. And again, if you go to the description of this video, you can click on the actual oral transcript and you can read along and see what justices are asking the question. And you can see how they constantly cut him off as soon as he makes a persuasive argument, which to me is insane. Now, what I'm going to do is, just to help everyone, I am going to paste. And by the way, moderators, please keep repasting this. Moderators, please keep repasting this link so you guys can read along for orals. All right. So here we go. Let's let Justice Sotomayor continue interrogating Alan Beck.
Under McKee, Justice Holmes looked for evidence, quote, that a practice had prevailed in Missouri where the suit originated. Whether you could collect shells in Missouri depended on whether there was a custom in that jurisdiction, correct?
The custom of the nation is what McKee holds, Your Honor.
It didn't. It looked at the custom of Missouri where the suit originated.
McKee specifically talks about the laws of a nation as being what's dispositive.
McKee, Justice Scalia did in Hardeen's, but the McKee, Justice Holmes wasn't talking about the tradition of the nation. He was looking at whether the tradition of Missouri permitted people to go onto land to collect seashells.
I have to disagree. The words nation appears in that. It looks at.
All right. Well, I'll look at it more closely. But at the time of the
But you see, guys, now I used to work for an appellate justice in California. It's not the job of a court, especially a Supreme Court justice, in my humble opinion, to try and argue on behalf of the other party. So, for example, this case really stands for this. It stands only for what the state says and the state's custom. And so the way Alan handled it was beautiful. And when you read the actual transcript, the way he handled it was beautiful. He didn't argue and say, you're wrong. He just simply said, McKee stands for this. Not that, no, it doesn't. No, it doesn't. I would probably do that. Now you got to imagine, and that's one of the reasons why I wanted to talk to Dick some more, because Dick actually had several cases before the Supremes. And I wanted to talk to you about how it must feel to like show up at the U.S. Supreme Court as a lawyer. I've argued cases before the Court of Appeal. I never made it to the Supremes. And your throat's dry. You're terrified because it's a really big deal as a lawyer, even as a private litigant. You just imagine newspaper reporters, video cameras. In this case, there's no video cameras allowed in the courtroom. They just all on audio or sketch artists. But here's Alan Beck. He's argued multiple cases before the Ninth Circuit. Amazing lawyer, but imagine the stress he's got to be under. But listen to the way he handles these things, just like a Marine under fire. I'm so proud of Alan Beck, guys. And I'm going to have him on for another interview soon, but I just want you to hear this guy.
Founding, or about the time, 71, 1721, 1722, up until the founding, there were at least 3 states who prohibited hunting, as you called it, or trespassing on private property with a gun, correct? So there was not a uniform national practice.
There was, Your Honor, of carrying on private property that's open to the public. Every case that every law that you're citing to deals with prohibitions on enclosed lands. And enclosed lands, there was those laws deal with, the enclosed lands were closed to the public.
Not necessarily. Look at Mount Vernon, where George Washington lived. There was a county shop there.
By definition,
that's a closed land.
Enclosed lands, I'd reference the amicus brief of the United States. They reference a law review article by Sigmund, and it goes into express detail that enclosed lands were closed to the public.
Counsel, do you agree, picking up on that Hawaii could pass a law that prohibited the carry without the express consent of the owner on lands that were closed to the public, on private residences?
I do not, Your Honor.
Really? Like, so I couldn't.
So this is Justice Barrett, and Justice Barrett is sort of a wobbler. Although she was appointed by a so-called Republican, it seems as though a lot of her opinions side with the left a lot. And I've had several of my viewers say that the female justices, for one reason or another, just are against the Second Amendment. I don't know that that's necessarily true because I haven't seen her opinion, but you can tell a lot about how a justice is going to rule based upon the questions they ask. So now we have Justice Sotomayor. She was not really persuasive. We had Alan Beck clearly show that out of the one case that Sotomayor came up with, it really didn't apply in this instance because she was citing cases about enclosed lands. And what Alan's case is about, Wolford v. Lopez, is about private property that is open to the public. Private property that is open to the public. And so far, the justices have sort of ignored that and asked questions that are unrelated to this case, in my view. So let's keep listening.
Hawaii can't have that law about, my house or Justice Gorsuch's house?
Step one of the plain text would be implicated because we're talking about carry. And then Hawaii would need to justify that with a national tradition. And even assuming the 3 laws, I don't think 3 laws is sufficient to demonstrate a national tradition. So
but do you agree that all of the business owners and maybe also private property owners in Hawaii could get together and say, we don't want this, and they could not give consent? Let's say the law is flipped. It says it's illegal to enter if you have been denied permission to carry a gun on the property. You agree that all property owners could get together and say, we're denying permission, and they could put such placards up in their window, and then you would still not be able to carry a gun on 97% of the property in Hawaii?
Yes, Justice. Every private property owner has the right to affirmatively put up a sign or otherwise not give permission for people to enter property with a firearm. The crux of our argument is that Hawaii has flipped that historical default from them having to affirmatively say guns are not allowed here to the current law.
But I guess my question is, isn't that historical default that you're referencing really a default that is rooted in property law and not constitutional law, not in the Second Amendment? I mean,
Okay, so this is Justice Jackson. Okay, now let me see if I can get Dick in here because I know Dick's probably got something to say. Hey, Dick. Man, you're still real staticky, brother. Dick, try and go back to your settings on your phone. Can you hear me? Try and go back to your settings on your phone, Dick, and turn your Wi-Fi back on. Maybe it'll work now. So go into settings, Wi-Fi, and make it green. And maybe that'll solve the problem.
It's on.
Still having that static, huh? Okay, so now turn Wi-Fi off. Let's see if that helps. This is just so weird, guys. Now he's got it off. Guys, when Dick started out, we had full reception. Everything was great. Then as the show gets going, all of a sudden he's got all this static. I mean, that to me is really disconcerting. Try talking again, Dick.
1 gun, 2 guns, 3 guns, static.
How many bars do you have, Dick?
2 and 3 out of 4.
Wow, that is so funky.
Yeah.
Try turning your Bluetooth off because it could be.
Let me live for a few minutes and come back.
Roger that, and I'll just keep going, but keep listening on YouTube, Dick. You can listen. If you go to the @Michael Ehline channel and you open it up and you click live, you can follow along on YouTube and watch because I don't want you to miss anything while you're logged out. Okay. All right. We'll see you soon. Okay, guys. So now this is Ketanji Brown. She is the Biden appointee. And she appears to be arguing, from my view, that the racist black code laws should apply to restrict citizens of Hawaii from being able to conceal carry a firearm into a business that's open to the public, a private business that's open to the public, which historically has never happened. It's always been that if a business doesn't want you to bring firearms in their store, they can put a sign in the window. Okay, so let's go ahead and keep listening.
Argument that some have put forward is that this is really a property case, not a Second Amendment case. Yes, it is about guns, but the argument goes, what's really going on here is how states treat a private property owner's consent under circumstances in which everyone agrees that consent is required. You just agreed that consent is required. And so, fine.
So if I was at a deposition, I would say objection assumes facts, not an evidence, argumentative, because Alan did not agree that consent is required for a private citizen to conceal carry into a private property that's open to the public. Again, the leftist justices are leaving that out in trying to create a trap for the unwary, in my view, for Alan to fall into. But listen to how Alan handles it. But more importantly, read from the actual written transcript, because you're going to see that Alan handles this with kid gloves and, in my opinion, eviscerates these arguments wholeheartedly.
There are many states, and perhaps even most states, that say we're going to imply that a property owner who opens his property to the public is giving consent for people to carry a gun. Hawaii has said no. What we're going to do is we're going to say, even if you've opened your property up to the public, you still have to have express consent. We are not going to make our property owners put up signs or be the one that has to affirmatively express. The person who comes on has to have consent, as everybody agreed, and in Hawaii, that consent is expressed. Why isn't that and all the cases that speak to it in the historical record really about the property interests and property rights and not about the Second Amendment?
Because here the law at issue implicates arms-bearing conduct, Your Honor.
But that doesn't mean it implicates. What I'm suggesting is that it might affect, right? And the United States was here just last term talking about how you could have rights and regulations that affect someone's interests, but they actually don't implicate their constitutional rights. And so here I'm saying, yes, gun owners are going to be affected because the property owner says, no, I don't want you to bring your gun on unless you come to me and I give you express consent. But that doesn't mean it implicates their Second Amendment rights for the purpose of Bruen.
Well, in Bruen, the court said that there's a general right to carry.
A general right to carry on public property.
No.
Justice Barrett just explored with you the fact that you don't have a general right to carry on private property.
No, what Justice Barrett said is that you don't have a right to carry on private property that isn't open to the public. And you can see that Justice Ketanji is making an argument that has nothing to do with this case. So she's conflating private property like your house with private property that's open to the public. And so when I hear these arguments, obviously a CNN commentator is going to go along with it and not distinguish the difference. But listen to how Alan eloquently handles Justice Ketanji Brown. It's absolutely amazing to me how eloquent and how well spoken he is. I'm blown away, guys. I've read this transcript probably 100 times now, and every time I read it, I'm in shock that I know Alan and that Alan works with me on cases, and I'm just so proud to have him as a friend. I mean, this guy, give me a bunch of ones for Alan Beck. Give me a bunch. And moderators, if anybody's given me any super chats or purchased memberships, please alert me, because I'm not looking at the chat box right now. I'm trying to run the show. But anybody who does that, their questions go to the front of the line. Hit that like and subscribe button. Share this with your friends. This is extremely important, guys. This show today is one of the most important shows that I've ever done, because you get to go inside and see. When I hear you guys say, oh, left-right paradigm, there's no difference, listen to the leftist justices and then listen to the justices that support libertarian principles like Alan and I, and you'll see right away that there's a huge difference, maybe not with the politicians, but clearly with the people who support some of the issues that the politicians stand for. Let's keep listening.
It's a right to carry in public, Your Honor, and not
Right.
a right to carry on public property.
But you do agree that there is no right to carry on private property without the owner's consent, right?
Here, the Second Amendment is implicated, especially when anywhere you carry in public. And here, this lawsuit deals with private property that is open to the public.
I understand, but what I'm suggesting is that
But honestly, if the justice understood that, she would not try to conflate a private home with a private business that's open to the public. In other words, in order for a business to do business, they have to be open to the public. And so I don't know if you guys will remember this, but Martin Luther King Jr. Protested against the very concept that she's supporting. Remember, Martin Luther King Jr. Boycotted businesses that were open to the public because they refused to allow Black people in at certain times of the day or to eat at the public counter. And gun owners have basically become the new Black people in this country. They've been vilified by the left-wing run press, by people like Newsom and these other far-left Marxist-run states, to basically become like the new Black person. And it's just very interesting what's happened, how it's flipped. But I want you to just listen to how Alan vindicates himself and notice how, as he becomes more and more persuasive, the left appointed justices start cutting him off to the point where Chief Justice Roberts has to basically step in and say, for lack of a better word, let the guy finish his sentence. Keep on listening.
Suppose this lawsuit dealt with someone's house and it's not open to the public. Do you concede that there is no Second Amendment right to carry a gun into someone else's house?
I do not, Your Honor.
You do not
I do
concede.
not. You still be dealing with carry. If someone gives me an invitation, a general invitation to enter into their home, and there's a historical presumption that you're allowed to carry a firearm with you, then if the government passes a law that flips that historical presumption.
Right, but I'm just suggesting that the historical presumption is about the consent, not about your rights. We agreed at the beginning, I thought there was a general consensus that your right to carry is limited to the permission of the owner when you're talking about private property.
Right. So if somebody gives you permission to come onto their property, it's implied that if you have a concealed carry permit or you have a weapon on you, that you're allowed to come into the property with that weapon. However, if you don't have permission to come on the property, you also don't have permission to come on the property with a firearm, because it's the trespass itself, not the act of having a firearm on you, that matters. And so Justice Jackson tries her best to try to conflate the issues to make it seem like there's some kind of a big issue here. And by the way, guys, there's Justice Jackson, God bless her. I don't think that she's qualified in this instance because she's not making sense. Give me a bunch of ones if you agree. I think that her arguments are legally wrong, and I believe that she will be on the minority who rules against Allen and Wolford Lopez in the Wolford-Lopez case on behalf of the state of Hawaii. And I think that she's going to side with Barack Obama's former attorney, who is now arguing on behalf of the state of Hawaii that racist, black, anti-black codes that were not even laws. They were codes passed by a racist Union general after the Civil War, that black people didn't have the right to come onto private property with firearms. And they're using this as their historical analog to say that the people of the state of Hawaii don't have the right to conceal carry on private property that is open to the public. Again, I'm saying this for people that have just joined me. So here, let's get back into it.
You've already agreed that the Second Amendment right is I would say subordinate, but in the panoply of rights, the right to exclude is superior because the owner can say, no, you can't bring this gun in here. And so once you've done that, these laws...
But that's not true. What the law is the owner, is not about the owner saying, no, you can't bring this gun in here. It's about the owner giving express or implied permission for you as an individual to come on their land. It has nothing to do with the firearm itself. And so what she's saying really conflates a lot of different arguments, which to me is very disconcerting, because we have an appellate strike that, a Supreme Court justice who should know better, in my humble opinion.
That are about licensing or, implying that the owner has consented are all in the realm of property law, I think, and not in the realm of the Second Amendment anymore.
I don't see it that way.
You disagree? All right.
Yes, Your Honor.
Thank you.
Counsel, do you agree that the state as property owner could exclude someone?
This is Justice Barrett now. So she's more, allegedly more, they would say right wing, in other words, more pro Second Amendment. Let's hear what she has to say.
Not this implied consent law, but let's say that the state as property owner, put aside the fact that the sensitive places here include state-owned property. Assume that that's not so. Could the state, as a property owner, say that you can't carry a gun onto state-owned property as a matter of consent under property law?
No, Your Honor. I think that's a different analysis because
Okay, why?
now we're dealing with direct state action.
And the state doesn't have the right as a property owner to limit who carries a gun, say, into the governor's mansion?
I think that there are certain locations that where...
So it's all a matter of sensitive places?
Yes, Your Honor.
Counsel, you make an argument.
So really quickly, let me just sort of break down sensitive places. Okay, historically, people did not have the right to bring a gun into a courtroom, for example, or a place where there were already armed people there who could provide protection to the public. So this has to do with the dangerous and unusual common law propositions. So the leftist judges at the Ninth Circuit will argue dangerous and unusual has to do with the firearm itself. Well, no, it doesn't. Under common law, which is what our natural law rights, where our natural law rights come from in this country, or at least what distinguishes our natural law rights, dangerous and unusual had to do with the time, place, and manner in which you could carry a firearm. Now, in a sensitive place, there's already armed security there. So it's implied that there's already somebody there who will protect you. And so therefore the state can pass a law that prevents you from bringing a firearm onto that property. Give me a bunch of ones if you understand the difference. Now let's go ahead and let the next justice, and this is going to be, so this will be Justice, because I can't tell all their voices yet. I'm not a pro at this. I've never argued a case. Justice Gorsuch is the next justice. Let's listen to what Justice Gorsuch has to say. So he would be considered more of a centrist or a conservative. Let's listen to what he's got to say.
That Hawaii effectively destroys the right to bear arms. You discussed that a little bit with Justice Thomas and with Justice Sotomayor. And I'm wondering where you think that analysis fits into the two-step Bruen framework the court announced.
In this case, step one merely deals with the fact that the state of Hawaii, that carry is implicated here. And once we go once we accept that carry is bearing a arm is at issue here, everything else is dealt with under step two, the historical analysis portion of this analysis, Your Honor.
So it really doesn't matter whether it was actually 96%, which we know it's not.
So this is Justice Sotomayor. She's harping again on Alan's argument that based on what Hawaii is trying to do, it's going to affect the people's ability to carry a firearm concealed effectively on 96% of the land in Hawaii. And she keeps going back to this. And now let's hear how Alan handles this. And let's hear how she constantly cuts him off whenever he starts making a persuasive argument. Very disconcerting.
Because you're dealing with the law as a whole. There's no means and scrutiny permitted by Bruen, correct?
Interest balancing has been abrogated by
Bruen.
Yes,
So there's no interest bearing. So if, in fact, if Hawaii has a right to regulate a custom as opposed to a constitutional right to bear an arm on private property, then tough luck, correct?
We have established in our briefing, Your Honor.
Counsel, there's no means ends. So if they overregulate or underregulate, that's irrelevant. Is there a right to carry a gun?
As we know from Rahimi, there's a general principle that dictates that you have a general right to carry. And when the government violates that rights, then because it violates that principle, then the second...
That's the interesting part. There certainly was a principle of the states regulating hunting on private enclosed property. There was a history of, in at least New York, in 1763, just before the founding, that prohibited trespassing and hunting on other people's lands because trampling on the land was destroying it. So you don't need, under Rahimi, an exact duplicate historically. You just need an analogous principle. If the states could regulate there, why can't they regulate here?
Well, very simply, those laws are not anywhere close to the law at issue here. The state has pointed to a number of anti-poaching laws on property that was not open to the public, whereas here they're regulating a specific type of carry for self-defense on private property open to the public. I mean, these laws are just simply not...
But what's open to the public and the license that you have to use that land is subject to custom.
It's subject to a national tradition that we had at the time of the founding, Your Honor. It's not, a specific custom that exists right now.
If means and ends is not a part of our equation, I don't understand what pertinence that has.
Because in order to do the Bruen analysis, we look to see whether a law is implicated by the Second Amendment right. Then we look to see what the historical tradition was in this country.
But that
Counsel?
seems... I'm sorry. If you could regulate to not trespass, trample the ground, if you could regulate not to hunt, if it's not means and ends, why can't you regulate simply to switch a presumption that gives the owner the right it has to give you express consent to say yay or nay to carrying the gun?
Well, for two reasons, because that violates our nation's historical tradition of firearms carry, and two, it violates a principle that...
But we didn't have...
Counsel, I see that your red light is on.
Yes, Your Honor.
We've been talking about private property and public property. A gas station on the side of the highway is private property. It's owned by the gas company or whatever. Do you assume that you have the right to go on that private property?
So this is Chief Justice Roberts, by the way. So he would be the most pro-natural law justice that we have, I believe, in most instances on the court. And you can still see that the left-wing appointed justices keep conflating between private property open to the public and private property as a whole. Now, basically what they're saying is, shouldn't a private property owner be able to decide who can come into their business? Well, that's precisely what Martin Luther King Jr. was fighting against. No, if your business is open to the public, basically her argument, in my view, says that, well, you should be able to discriminate against black people coming on your property. And people would immediately say, well, wait a minute, that's different because this has to do with the Second Amendment. Black people are protected under the Constitution. Well, guess what? The Second Amendment is also protected under the Constitution. So you constantly see the Marxist view that firearms should not be afforded the same protections as race or speech. The First Amendment and the Second Amendment obviously protects the first. And so you see this constantly happening. And in my view, it's a very hypocritical point of view that some rights are more important than others. Put it in the chat if what your opinion is on this. I want to hear what my audience has to say. Let's listen to Chief Justice Roberts and let's see what he's got to say.
Property, even without any express permission,
Yes, Your Honor.
even though it's private property?
Yes, absolutely, Your Honor.
Is it a different analysis or the same analysis when you're talking about a dwelling along the side of the of a road?
That's a different analysis, Your Honor. You have to see whether there's some sort of invitation to come in there.
Is there, under our law, an invitation, for example, for people soliciting, for people who want to drop off pamphlets about a particular?
Yes, Your Honor. Up to the doorknob or the car, there is.
Even though it's private property?
Yes, Your Honor.
Stranger can walk off the sidewalk and go up to the door?
Yes, up to the door, Your Honor.
Thank you. Justice Thomas? Justice Alito?
Under Hawaii law, are there any other objects besides guns that a person may not possess when that person enters private property that is open to the public?
Not to my knowledge, Your Honor.
Thank you.
Justice Sotomayor?
In Hawaii for 200 years, there's been no custom of carrying weapons, correct? Up until Bruen and Heller.
Up until Bruen, you could not get a license to carry a firearm, Your Honor.
So 78% of Hawaii residents and 64% of Hawaii gun owners do not think that loaded concealed weapons should be allowed into businesses at all, correct?
Objection assumes facts, not an evidence. And by the way, the premise of her comments are that King Kamehameha's laws that were passed before Hawaii became part of the United States should apply. So King Kamehameha outlawed the ability. And by the way, prior to this, there was a historical duty for Hawaiians to be armed so as to protect their women. I think it's called the paddle law, where they had these paddles that had shark's teeth. But when he came into power, he wanted to consolidate power. So King Kamehameha outlawed the ability of the Hawaiian people to keep and bear arms. And so what she's arguing is, well, prior to it becoming a state, there was no right of the people of Hawaii to keep and bear arms. Well, that had to do with a monarch. Now, keep this in mind, guys, that we fought a civil war. We fought a war against England because the king, primarily the reason we went to war, is the King of England tried to seize the colonists' powder houses where we stored our gunpowder. And that's really what sparked off the American Revolution. They don't teach this in the public schools, definitely not in the Marxist-run campuses. But she's basically arguing that a monarch's law that deprived the people of the ability to defend themselves, their home and hearth, because the law, the tradition of Hawaii, prior to it becoming part of America, their historical tradition is that they couldn't have firearms. So I just believe these arguments are unsound, and it's a hodgepodge of arguments that no justice who's qualified would properly decide as being valid, in my humble opinion. Put it in the comments what you think so far. And guys, let me know if my narratives are not being helpful, because I know you're not lawyers. So I'm trying to break it into layman's terms so you can sort of understand. Because before I was a lawyer, I wouldn't have known how to make heads or tails of any of this. So I need to know if my audience likes it, that I'm sort of trying to explain things for them in a way that a common man would understand, or woman. Just let me know. Here we go.
I'm unaware of that statistic, Your Honor.
I wasn't aware of your 96% number either. Nothing about Hawaii's customs, tradition, or culture creates an expectation that the general public carries guns wherever they go, correct?
Hawaii is part of the United States, and as part of the United States, our national tradition is that people are allowed to carry on private property that's open to the public.
Hey, Dick, can you hear me now, buddy?
Yes.
Okay, we still got a little bit of static from you, but have you been listening so far? Dick? Still sounds like we got static. All right, I'm going to put Dick on mute. I don't think you can hear me, but I just want you guys to know this is Dick Heller from District of Columbia versus Heller, and it's the seminal law, which means it's the number one law from which all of these cases spring from that Alan Beck is arguing, and he is the man who started it all. So I want you guys to give me a bunch of ones for Dick, because I am just so proud to have him on my show today. I'm just giddy. Now, Pro Se America says that the reason why he believes Dick is having a problem with his audio is Bluetooth interference. He believes that Dick has Bluetooth on, and that's causing him to automatically roam, which is causing trouble. So, Dick, I've got you on mute right now, but take a look on your phone and just make sure your Bluetooth is turned off. And, make sure you've got bars. And sometimes if you're not connected to your Wi-Fi and you go back on your phone's normal feature where it's coming directly from your internet, strike that, your phone company. And if you just walk around, you're going to be able to find that you have a really good connection. But right now, it's not that important that we have Dick here to narrate. It's more important for me spiritually to know that I have Dick Heller on the show with me, a historical figure. And Pro Se America said it right. Dick Heller is my hero, bunch of ones. And Dad says Sharia law seems compatible with Marxism. Well, I agree, Dad. And Dad, here's another interesting historical fact for you. Heinrich Himmler started the SS Handschar units. The Nazis had their own, the SS, the Waffen SS. And Heinrich Himmler said that he would have preferred that Germany was Muslim, because Muslim is a religion of submission. And so if he had a bunch of submissive people, like a caliphate, that he believed that would make Nazism stronger. And then he started the SS Handschar. So the Nazis actually had Muslim units called the SS Handschar. You can Google that if you don't believe me. Don't want to get too far off, but I just wanted to share that with you because, Dad, I think you're right. Sharia law does seem compatible with Marxism because it supports the concept of centralized control over every aspect of your life. Now, Zoom with Smokey Bear says, I do understand what you're saying. And then Pro Se America says, it was the Kingdom of Hawaii, not the United States. They're using Hawaii customs before they were in the Union. It's BS, and it doesn't meet the Bruen standards. Absolutely agree with you there, brother. And I see, Dad, your comments about Marxism is incompatible with American values. Duh. And let me see what else I can see. Life Under the Microscope says they're corrupted. Well, I don't know who you mean by that, but I could read in between the lines. And again, anybody who has questions, by the way, guys, hit that like and subscribe button and share this link with everyone you know. There's no reason why we shouldn't have 3,000 people in the chat right now. It's very disconcerting. We have a historical figure, Dick Heller, and we have one of the most important cases that my firm or any attorney associated with my firm has ever argued. It's before the Supreme Court, and I'm actually giving you the blow-by-blow and letting you hear what it's like to argue a case before the Supreme Court. This is a really big lesson in civics, so please make sure that all your friends know what's going on, guys. Here we go back with the arguments.
This law is not banning you from doing that. It's just requiring you to get the owner's permission, correct?
And here, the law has always been that you had an implied right to enter onto
Not in Hawaii.
As Hawaii is part of the United States, Your Honor, and
but if it's a local custom that controls,
it's not a local custom that controls. It is the
where
custom.
else in the law have we permitted local custom to create a constitutionally protected right?
Bruen was very clear here that we're dealing with our national tradition, Your Honor. It is not local custom that controls in this area of law.
Justice Kagan?
Mr. Beck, the various statutes that Hawaii has cited as going to the Bruen Step 2 question, you say they're not close enough, and I guess I want to know why. I was struck by the fact that there are quite a number of statutes that do exactly what this law does. They flip a default rule as to...
And here's Sotomayor again, basically, in my view, sort of arguing on behalf of the state of Hawaii. for the proposition that you shouldn't be able to conceal carry unless you have everybody's permission, even though it's a private property that's open to the public.
How explicit consent has to be. You know, they recognize that you don't have a right to go in without consent. You do have a right to go in with consent. And then the question is, how do we determine consent? And what default rule do we start with? And I guess what struck me about these statutes and about how close they are is that that's exactly what each of these statutes did. So why isn't that pretty good evidence under Bruen Step 2 that this is something that states historically have done?
The state is not cited to a single case that is relevantly similar to the one at issue here. We've got basically two sets of laws. One were the anti-poaching laws that dealt with private property that was not open to the public, one. And part of that also is there were exemptions for people to be able to carry firearms onto those lands that for purposes of self-defense. So land that's not open to the public, where you still have a self-defense right, isn't relevantly similar to the law at issue here. And the other sets of laws that have been cited to are black codes. And those can't be relevantly similar. As Justice Kavanaugh said in Rahimi, we've moved away from that history. And in addition, it dealt with a very, discriminating against a very small subsection of society rather than prohibitions on the general right to carry.
So I'm going to stop Alan right there. Dick, how's your audio doing, buddy?
Can you hear me? I'm working on it.
Now I can hear you, but you sound like you're really far away.
Yeah, I'm working on the volume now. I found a cancellation button hidden somewhere in Safari.
Okay.
I barely hear thing. I'm trying to get my volume up.
Fair enough. Well, I just wanted to know if you've been listening to Alan's arguments and to let you know there's feedback coming in, like your volume's up so loud it's feeding back through. So we're hearing my voice twice, just so you know. But we're going to figure this out, Dick, because I know you're going to have a lot of things to say. But so far, what do you think of the job that Alan's doing here?
Mr. Walking Encyclopedia is above my pay grade, sir.
There you go. Your audio's good.
Okay.
Well, it was, and then it went back off. But
yeah, it goes up and down.
Okay, so guys, I've got Dick Heller of District of Columbia versus Heller, the seminal case on gun rights, and I've got him here in the chat with me. And we're just listening to the Wolford case that Alan Beck just argued before the Supreme Court on 120 of 26. And I'm trying to give you a blow-by-blow of the oral arguments. So I'm going to put Dick back on mute because there's feedback coming through. When I talk, you can hear it coming through twice. But only 13 people in the chat. This is disgusting. That tells me that the YouTube algorithm is doing everything they can to shut us down. So guys, I'm going to ask that everybody in this screen right now, everybody who's part of Team MPE and who believes in the Constitution, share this link with your friends, your family. Let's get more people in the chat. There should be people getting paid subscriptions and trying to help us build this channel, because where else are you going to find a natural law rights attorney who's standing up for we the people, who's not like a guy like Alan Beck, who's paying for most of this case out of his own pocket to get before the Supreme Court? I mean, you've got true believers here who believe in you. SW Observer, hell yeah, brother, I'm glad you're here. SW Observer is a Swede, and he doesn't like what's going on in Sweden either, with the open borders, flooding the country with people who refuse to assimilate with the population, the stripping away of the cultural identity of Europe, flooding their countries with sub-Saharan Africans who refuse to assimilate and accept the culture that they've invaded. And so I'm glad that you're here, SW Observer. Let's go ahead and get back into the oral arguments, and let's hear how Alan acquits himself.
Yeah, so let me go back to the first thing, the idea that these are anti-poaching laws. I mean, okay, Hawaii's is not an anti-poaching law, but I suppose I'm sort of stuck on the fact that that doesn't seem to be the relevant similarity. In Rahimi, we said, you can go up a level of generality. You don't have to have a historical twin. There can be differences. In Rahimi, the essential similarity that we thought controlled was just that the guns were being used to protect against people who would be violent.
So basically, she's trying to argue that since there's no case on point, an anti-poaching law, which means you can't steal game from someone's land, somehow should be substantially similar enough to prevent a legal licensed concealed carry weapons holder from carrying their firearm into a private property that's open to the public. And I don't see any similarity at all. I don't even see how you could make a comparison between an anti-poaching law and a constitutional right to keep and bear arms. Put it in the comments. What do you guys think?
With their guns. And, that's a pretty general principle. And here, the general principle is sort of similar. We think that there's a danger of various injuries occurring when you go onto private property with a gun. It might have been in the old days poaching. It might be something else now. But because that's so, we are going to use a default rule that says to the property owner, if you want this, okay, but you have to say you want it. It seems to me the same. It's a different injury. It's not poaching anymore, but it seems to me the same.
Does anybody see privately carrying a concealed firearm onto private property open to the public anywhere near similar to poaching and the property crime of theft? Does anybody see any kind of similarity there? I want to see what you have to say in the comments. I'm really confused at this point how this could even potentially be an argument.
State mechanism, the same kind of state regulation.
Yes, Your Honor, but one dealt with private property that was not open to the public, whereas this law is dealing with private property that's open to the public. And in addition to that, the anti-poaching laws also gave you a right to be able to carry firearms for self-defense. So I just simply don't see how the level of generality there would simply swallow the rule if this court were to accept those anti-poaching laws as being relevantly similar here, Your Honor.
Thank you.
Justice Gorsuch?
I mean, basically, he completely eviscerated her argument. The bottom line is you still have the right to carry your firearm in this area for purposes of self-defense. And that is the whole purpose of a concealed carry law. To me, it sounds like a bunch of Harvard or Yale law clerks helped these justices come up with these arguments, which would work really well on a woke college campus where nobody has the right to dissent. They all have to agree that wokeness is the rule. And so they were not prepared for any of Allen's arguments. It's clear to me that whoever is feeding the justices this line of questioning or inquiry were not prepared to go up against somebody with Allen's experience, knowledge, and skill. Give me a bunch of ones for Allen Beck, who I'm proud to say I work on cases with, and extremely proud of him. Let's keep going with the orals.
Your friends on the other side in the Ninth Circuit relied on two statutes in particular. One was the 1771 New Jersey law that you were just discussing with Justice Kagan. But the other one that was left unmentioned was an 1865 Louisiana statute that was adopted immediately after the Civil War as part of an effort, it appears, to disarm black people.
And again, notice the female that you just heard was Justice Kagan. And you're going to hear later in these arguments that Justice Bruen says that this was a wartime law, the black codes. It was during war. So even historically, she got it wrong. This was a post-Civil War, and it wasn't a law. It was a military ordinance passed by a Union officer without a vote to restrict black people from keeping and bearing arms. And so we've got Kagan and then Justice Bruen arguing, well, at least it sounds like they're saying, oh, this law should apply. And you have Barack Hussein Obama's private lawyer hired by the state of Hawaii. And this is his primary argument for restricting people to conceal carry on at least 90 to 96% of the land in Hawaii. In other words, there is no concealed carry right anymore. And that's how the Marxists do it. It's a Marxist play. Let's hear what this justice has to say.
The instruction governor later explained that this law, of course, was aimed at the freedmen. Do you think
and this is Justice Gorsuch. I'm going to go back and let you guys hear. This is Justice Gorsuch talking about the post-Civil War black codes.
At the time of the founding, Your Honor, it's not, a specific custom that exists right now.
If means and ends is not a part of our equation, I don't understand what pertinence that has.
Because in order to do the Bruen analysis, we look to see whether a law is implicated by the Second Amendment right. Then we look to see what the historical tradition was in this country.
But that
Counsel?
seems, I'm sorry. If you could regulate to not trespass, trample the ground, if you could regulate not to hunt, if it's not means and ends, why can't you regulate simply to switch a presumption that gives the owner the right it has to give you express consent to say yay or nay to carry the gun?
Well, for two reasons, because that violates our nation's historical tradition of firearms carry, and two, it violates a principle that...
But we didn't have...
Counsel, I see that your red light is on.
Yes, Your Honor.
We've been talking about private property and public property. A gas station on the side of the highway is private property. It's owned by the gas company or whatever.
I went back a little too far, but at least you get an idea. I believe this is Sotomayor, and then I think we're going to have Gorsuch, and we're going to have Kagan. But just listen, guys, because now I think I've given you enough narrative to where you have a better understanding of what's going on here.
Do you assume that you have the right to go on that private property even without any express permission?
Yes, Your Honor.
Even though it's private property?
Yes, absolutely, Your Honor.
Is it a different analysis or the same analysis when you're talking about a dwelling along the side of the of a road?
That's a different analysis, Your Honor. You have to see whether there's some sort of invitation to come in there.
Is there, under our law, an invitation, for example, for people soliciting, for people who want to drop off pamphlets about a particular...
Yes, Your Honor, up to the doorknob or the car, there is.
Even though it's private property?
Yes, Your Honor.
Stranger can walk off the sidewalk and go up to the door?
Yes, up to the door, Your Honor.
Thank you.
That's right, and that's an implied license. That's why solicitors are able to walk up to your door, but if they see a no soliciting sign, they're not.
Justice Thomas? Justice Alito?
Under Hawaii law, are there any other objects besides guns that a person may not possess when that person enters private property that is open to the public?
Not to my knowledge, Your Honor.
Thank you.
Justice Sotomayor?
In Hawaii for 200 years, there's been no custom of carrying weapons, correct? Up until Bruen and Heller.
Up until Bruen, you could not get a license to carry a firearm, Your Honor.
So 78% of Hawaii residents and 64% of Hawaii gun owners do not think that loaded concealed weapons should be allowed into businesses at all, correct?
I'm unaware of that statistic, Your Honor.
I wasn't aware of your 97.
Well, probably CNN gave her that talking point, but that's simply not a fact before the court, and so it shouldn't be considered. So when you argue a case before the Supreme Court, you have to present evidence in advance, and there's no evidence on the record of that being true. So just a little interesting tidbit, asking a leading question of the moving party, the appellant, and he's not going for it. Let's hear how Allen acquits himself.
96% number either. Nothing about Hawaii's customs, tradition, or culture creates an expectation that the general public carries guns wherever they go, correct?
Hawaii is part of the United States, and as part of the United States, our national tradition is that people are allowed to carry on private property that's open to the public.
This law is not banning you from doing that. It's just requiring you to get the owner's permission, correct?
And here, the law has always been that you had an implied right to enter onto
Not in Hawaii.
As Hawaii is part of the United States, Your Honor, and
But if it's a local custom that controls.
It's not a local custom.
It was a local custom under the King of Hawaii, who disarmed his own people in order to consolidate power. The same way the King of England tried to take away the colonists' right to keep and bear arms. Very, very interesting how we basically have our own Supreme Court arguing in favor of what the King of England's position was at the time of the Revolution. What do you guys think about that?
Where else in the law have we permitted local custom to create a constitutionally protected right?
Bruen was very clear here that we're dealing with our national tradition, Your Honor. It is not local custom that controls in this area of law.
Justice Kagan?
Mr. Beck, the various statutes that Hawaii has cited as going to the Bruen Step 2 question, you say they're not close enough. And I guess I want to know why. I was struck by the fact that there are quite a number of statutes that do exactly what this law does. They flip a default rule as to how explicit consent has to be. They recognize that.
And this is Justice Kagan. This is what you would consider to be part of the left wing of the court. So Justice Kagan is basically saying, there's quite a bit of laws that could be flipped on their heads. And just listen to what she's got to say, because the laws that she's talking about don't have to do with a constitutionally protected right. And so this is very, very disconcerting to me. The left wing of the court is stretching so hard to make sure that the people of the state of Hawaii, protected as a constitutional republic, should not be able to conceal carry unless otherwise restricted by the property owner in advance. Let's keep listening. It's very, very disconcerting. Let's go.
You don't have a right to go in without consent. You do have a right to go in with consent. And then the question is, how do we determine consent? And what default rule do we start with? And I guess what struck me about these statutes and about how close they are is that that's exactly what each of these statutes did. So why isn't that pretty good evidence under Bruen Step 2 that this is something that states historically have done?
The state is not cited to a single case that is relevantly similar to the one at issue here. We've got basically two sets of laws. One were the anti-poaching laws that dealt with private property that was not open to the public, one. And part of that also is there were exemptions for people to be able to carry firearms onto those lands that for purposes of self-defense. So land that's not open to the public, where you still have a self-defense right, isn't relevantly similar to the law at issue here. And the other sets of laws that have been cited.
And all I can say is, wow, just wow. She's citing laws and citing propositions that have zero relevance. And this is a justice of the Supreme Court basically citing things that are not even remotely relevant to the arguments at issue here. And Alan's not going for it, but the way he does it is so eloquent and civil that you can't come after him for being a psycho or, kind of like Lane Myers, that I think they ruled against Lane because of his personality. And so he takes away that argument by being so civil and so gracious in the way that he presents his arguments. Very impressed with Alan here.
Are black codes, and those can't be relevantly similar. As Justice Kavanaugh said in Rahimi, we've moved away from that history. And in addition, it dealt with a very, discriminating against a very small subsection of society.
Whoa, hold on a minute, guys. Zoom with Smokey Bear. He said he just shared the show with a bunch of channels, and he donated $20 to the Team MPE cause. Zoom with Smokey Bear 2597. Look, man, I really appreciate it. And by the way, I have a brother here who's disabled, is Lynn Davidson, 2126. I just did a giveaway for a 1/10 ounce piece of gold. We'll be announcing the winner of that. Well, I'll be sending the winner who donated the most money to Lynn Davidson to win that 1/10 ounce piece of gold. He's got no cold water. And this is what this channel is all about. I believe that when the government says I'm here to help, that's when you run. I believe that private people like us can form parallel systems the same way that Martin Luther King Jr. did. And we can change the system without the government being involved by being grown-up private citizens. So if anybody wants to help out Lynn, unfortunately, the gold giveaway is no longer valid. It's off, it's off the radar. But in the future, I'll probably do a constitutional silver giveaway to continue helping Lynn. But if anybody wants to help Lynn, I vouch for him. He is a fellow patriot. He supported this channel for about, I guess, 2 years now. And he's part of my Cop Watcher community, where I started out with help from Chile de Castro. When Chile got locked up, I helped him run his channel. And so Zoom with Smokey Bear, I do appreciate exactly what you're doing to help the channel. And just so you guys know, it's not easy for me to do these shows. I've got a back injury. I'm not feeling too well today. I'm hopped up on pain meds, but I'm doing this because I want to help people. And I want you guys to get another source of information other than the brainwashing from CNN and all these other leftist so-called news channels, to where you can find out about your rights without getting the narrative from some jerk who's been brainwashed in a far left institution like a college or a public school. So you can learn a real civics class. So yeah, definitely support Lynn if you can afford to, even if it's just a couple of bucks. Help this guy out so we can get him some warm water, so he can take a shower at least. So Lynn, yeah, give me a bunch of ones for Lynn for supporting the channel. I believe he's also one of my moderators under a different handle. He's using a different handle today. But make sure to share this with everybody. And let me just look if there's any more comments here. That's right, Pro Se. It doesn't meet the Bruen standards. And now Mod Mojo 6629 says, I wish the attorney would ask the justices, does your First Amendment stop you from going on private property? Well, yeah, I mean, there's so many questions I'd like to ask as well. But remember, he's arguing before the U.S. Supreme Court, and that's no joke, man. So the fact that he's keeping it together and making these solid, profound arguments is impressive to me. So let's listen to what what many would call the far left justice has to ask Allen and see how he acquits himself.
Rather than prohibitions on the general right to carry.
Yeah, so let me go back to the first thing. The idea that these are anti-poaching laws. I mean, okay, Hawaii's is not an anti-poaching law, but I suppose I'm sort of stuck on the fact that that doesn't seem to be the relevant similarity. In Rahimi, we said, you can go up a level of generality. You don't have to have a historical twin. There can be differences. In Rahimi, the essential similarity that we thought controlled was just that the guns were being used to protect against people who would be violent with their guns. And, that's a pretty general principle. And here, the general principle is sort of similar. We think that there's a danger of various injuries occurring when you go onto private property with a gun. It might have been in the old days poaching. It might be something else now. But because that's so, we are going to use a default rule that says to the property owner, if you want this, okay, but you have to say you want it. It seems to me the same. It's a different injury. It's not poaching anymore, but it seems to me the same state mechanism, the same kind of state regulation.
Now, listen to how Allen distinguishes what she's saying, because she's literally citing a law, a case, that specifically says within the four corners of the decision that even though it might be illegal to poach, you still have the right to carry a weapon for self-defense. And she's arguing, well, it's a potential injury. Someone who's a licensed concealed carry holder, in other words, someone who's not a danger to the public, it's a potential danger to have them go onto property with a firearm. The issue is they're going onto that property with a concealed weapon for purposes of self-defense. And Rahimi specifically distinguished that you do have the right to go on land if you're not poaching to have a firearm. And so the arguments that she's making don't pass what they call judicial muster. So if you want to look that term up, guys, they don't pass what's called judicial muster. In other words, it muddies the waters and takes away from Allen's argument. But let's hear how Allen goes against what she just said, because to me, it's priceless.
Yes, Your Honor, but one dealt with private property that was not open to the public, whereas this law is dealing with private property that's open to the public. And in addition to that, the anti-poaching laws also gave you a right to be able to carry firearms for self-defense. So I just simply don't see how the level of generality there would simply swallow the rule if this court were to accept those anti-poaching laws as being relevantly similar here, Your Honor.
Thank you.
Justice Gorsuch?
Your friends on the other side in the Ninth Circuit relied on two statutes in particular. One was the 1771 New Jersey law that you were just discussing with Justice Kagan. But the other one that was left unmentioned was an 1865 Louisiana statute.
So when he says your friends at the Ninth Circuit, he's talking about the leftist judges at the Ninth Circuit. And Allen just distinguished the Rahimi case, where Rahimi specifically holds that you do have the right to go on that land for purposes, to have a firearm for purposes of self-defense. Now, Gorsuch gets into the anti-black racist post-Civil War military ordinance passed by a racist Union general or Union officer that prohibited black people from keeping and bearing arms. And this is what Barack Obama's attorney argues on behalf of the state of Hawaii for the proposition that you shouldn't be able to have a concealed carry on private land open to the public. So Gorsuch eloquently brings this up, and it's really amazing how Allen deals with this.
It was adopted immediately after the Civil War as part of an effort, it appears, to disarm black people. The Reconstruction governor later explained that this law, of course, was aimed at the freedmen. Do you think the black codes, as they're called, should inform this court's decision-making when trying to discern what is this nation's traditions?
I do not, Your Honor.
Well, your friend on the other side says it should, and that the 1865 statute is a, quote, dead ringer for this statute.
And when he says your friend on the other side, he's talking about Barack Obama's private attorney who is hired by the state of Hawaii to prevent people in the state of Hawaii from being able to conceal carry pursuant to the Constitution. And this is Barack Obama's private attorney hired by the state of Hawaii. The best argument that he could come up with, besides an inapplicable anti-poaching law, was that a law that was passed to prevent the newly freedmen or blacks from keeping and bearing arms should prevent people in Hawaii from exercising their Second Amendment rights. And so it's really interesting the way that Gorsuch brings this up. But again, Allen handles this with precision.
The 1865 law was expressly passed to discriminate against African Americans that were newly freed slaves.
And by the way, it wasn't passed. This was a law that was issued by a Union officer. It was not passed by a legislature or anything like that. It's just called a Black Code, and it's a military law. So Admiralty Maritime Law would be how this was applied. Basically a law that was passed by one person. So in that regard, it was passed. It was passed by an officer during Reconstruction.
And I just don't see how a law like that can be used to be analogized to a modern-day law, this modern-day law, Your Honor.
Justice Kavanaugh? Justice Barrett?
Do you agree with everything in the government's brief?
No, I do not, Your Honor.
The United States government.
Yes, okay. Your Honor.
The government that's on your same side.
Yeah, so again, When I hear people on my channel who have bought into the CNN narrative, left-right paradigm, there's no difference. This is the United States government joining our brief on behalf of the people of the state of Hawaii, arguing in favor of the Second Amendment. Now, if Kamala Harris had been elected, you would have had a government official at the DOJ arguing against our brief. Instead, we actually have the Department of Justice arguing in favor of the Second Amendment. I don't think this has ever happened in the history of our country. I believe it's the fourth time in history that the Department of Justice has argued alongside of a private citizen. This is a really big deal, guys. So that's why, look, guys, I'm not a so-called Trump supporter, but I got to tell you this. There are a lot of his positions that I agree with, like protecting our borders, keeping illegal aliens out of our country until they have qualified themselves as being worthy of being in our country and that they want to assimilate into our country. I believe in all that stuff. It doesn't mean that I have to support ICE, but I got to tell you something, guys. ICE wouldn't be needed if Joe Biden hadn't flooded our country with 20 million illegal aliens who we have no idea of who they are, issued them social security numbers, sent them to sanctuary cities so they can redistrict to keep Democrats in power. If Democrats want to win elections, let them win fairly, but manipulating the United States Census to create more voting districts is improper. Give me a bunch of ones if you agree that it's okay to not throw the baby out with the bathwater. You don't have to support President Trump or like him, but it's okay to support many of his positions. Give me a bunch of ones if you agree with that, that just because you don't like him, the bottom line is the reason why Alan Beck is up here arguing this brief right now, having the Department of Justice on his side, is precisely because Donald Trump was elected. If it would have been Biden or Kamala Harris, this argument would not be taking place. So this whole argument that there's no difference between the parties, well, there may be no difference between the parties with respect to being corrupt, being reliant on bankers and the Federal Reserve banking system to keep power, insider trading. That's probably true because I've lobbied Congress and I think they're a den of vipers. But I am very grateful as a single issue voter that we have the Second Amendment here, and we have the DOJ for once arguing in favor of the people instead of arguing against the people. So let's hear more from these oral arguments.
Yes, I understand. I agree with
I'm not asking you to throw your case away.
I fully endorse the United States brief, Your Honor.
Okay, and then I just have one clarifying question. When Justice Kagan was pressing you on the analogies between the anti-poaching laws and Hawaii's law, one of the things that you used to distinguish it was that the anti-poaching laws applied to private property, and these applied to property that's open to the public, albeit private. But I thought you had initially told me that Hawaii couldn't do this with respect to property that was like a dwelling, a private residence either, that was not open to the public.
Well, what I'm saying is that that's a different historical analysis, and if they were to muster enough historical analysis to justify the law, that might be true. I just don't think that they've developed enough history on this record to be able to justify that law, Your Honor.
Justice Jackson?
The Chief Justice asked you about a gas station on the side of the highway.
So really quick, before we hear Justice Jackson, which most legal scholars would agree, her arguments and her comments just don't pass any kind of judicial muster. It's almost like talking to yourself so you can hear yourself talk. But really quick, I want to hear Dick. So Dick, do we have comms now?
Can you hear me?
You sound like you're really far away, but I don't hear the background distortion anymore. But guys, can you hear Dick? All I hear is background, and then I hear interference where you can hear me talking over his phone.
Okay.
Okay. Well, we're going to get back into the arguments, Dick. Hopefully we can get your comms. But guys, we've got Dick Heller of District of Columbia versus Heller, the seminal case on firearms rights. here in the chat with me today, but unfortunately there's some comms problems. But I'm going to get into some questions in the sidebar here. A comment from Bruen 1791. I agree with that narrative. This wouldn't have happened under Biden, but MAGA is still defending the PDF files. Right, but that's the issue, Bruen, is that we're not here to talk about Epstein. We're here to talk about a single issue, which is the Second Amendment. And all I could say about that is Barack Obama and Joe Biden had more than enough time to release all the Epstein files. And so far, the only president who's released some of these files is Donald Trump. So, but with respect to this particular issue that we're talking about, it sounds like you're falling into the CNN narrative that we need to throw away the baby with the bathwater. We need to throw away the baby with the bathwater, even though we finally have a Department of Justice who's arguing in favor of we the people to keep and bear arms. And all I'm saying is there is a huge difference between the left and the right. There is no paradigm, as a lot of these cop watchers say. There's a huge difference between the people who vote for them. The people who vote for them have strong views. People on the right believe that there's a difference between biological males and females. People on the left don't. People on the right believe that you have the right to keep and bear arms. People on the left don't, unless maybe it's for hunting, right? So there is a huge difference in what the people who support these causes have. And so you don't have to be a Trump supporter to support the Second Amendment. You don't have to be a Trump supporter to believe that keeping illegal aliens out of our country is a good thing. You just have to be someone who believes in the Constitution in a constitutional republic. So don't buy into the CNN narrative. Be free thinkers. Thanks, Bruen. I appreciate that, brother. Because I'm not here to try to argue with you or try to make you into an enemy. I'm here to explain that there's a huge difference between the people who vote. And yeah, we aren't happy about a lot of the things we're hearing about Trump and all that. But I'm here to support Alan Beck and the free people of America who believe that we have a right to keep and bear arms. And right now, today, you get to hear Alan Beck make mincemeat of the state of Hawaii's absurd arguments that racist black codes should apply. And the fact that we have a black Supreme Court justice jumping on to Barack Hussein Obama's private lawyer's argument, and he's on the opposite side arguing for the state of Hawaii, that racist black codes, post-Civil War black codes that prevented newly freed black people from keeping and bearing arms should apply. And to me, it's what a slap in the face for every person who identifies as being an African American. It's absolutely absurd. I can't even, it makes me want to throw up. I don't know about you guys, but I get sick to my stomach hearing this. It's just insane. But let's listen to what Ketanji has to say.
Which is private property. It's open to the public. And you said that we presume that a person can go in under those circumstances. Is that right?
That's correct, Your Honor.
All right. I guess what I'm positing is that the reason we presume that a person can go in is not because they have a constitutional right to go in under the Second Amendment or anything else. The reason we presume they can go in is because property law implies that a gas station owner who has private gas station.
Okay, and by the way, I want you to understand what's going on here. The justices on the left are trying to argue that this case does not present a constitutional right under the 14th Amendment or the Second Amendment. This is really just a property rights case, and therefore a lower level of scrutiny needs to apply, like rational basis. In other words, well, if there's any rational basis at all for the law, then the law needs to apply, because it really doesn't have anything to do with guns. It's really about just, the state's ability to regulate a property dispute. And so as people who aren't lawyers, I need you to understand what these justices are doing on the left. They're trying to reduce Alan's case to a rational basis standards instead of a higher standard of like strict scrutiny or even intermediate scrutiny, in order to prevent the people of Hawaii to be able to keep and bear arms. A lot of you guys who don't understand the law don't get it. And that's why I like to be here to explain these things to you. So give me a bunch of ones if you guys think that I'm cool with my explanations. And then, by the way, Wanda Mise, good seeing you, Wanda. Wanda says the states still violate 2A by restricting felons from gun ownership. Well, Wanda, look, I'm not gonna argue against that. I think that a nonviolent felon who's not an enemy of the United States absolutely should be able to keep and bear arms. And I think that President Trump has actually led the fight to try and get their firearms rights restored. In fact, you guys know I still do some criminal defense. It's interesting. Prisoners in jail, even black prisoners, overwhelmingly support Donald Trump, which is really interesting to me because, there's sort of a narrative that black people only vote Democrat and they only support Democrats. But in this case, Donald Trump has made a friend of these people for trying to restore their Second Amendment rights. So I think that's really interesting. Yeah, and Tracy, that's sort of an offhanded remark, but we know that lawfare had a lot to do with that conviction, and it will be reversed on appeal. But again, we're here to talk about the Second Amendment and the fact that we finally have a Department of Justice supporting we the people. And Tracy, I would be willing to bet $100 right now that you do not support the Second Amendment, and you probably vote for Marxist Democrats. So I understand your position, but it's really just an offhanded remark that has no application to this case. And I think that you should sort of revisit what you're saying. You've got an appellate justice over here, along with Barack Hussein Obama's private attorney, arguing that racist, anti-black laws should apply to prevent people in Hawaii from being able to conceal carry on private property open to the public. And me being a recovering Democrat and now a libertarian, not a Republican, find it really insulting that you're so hypocritical that you would overlook that just because you hate Donald Trump so much. And so with politics, no, it will be overturned on appeal. I didn't say that it was, but again, you sound like a typical Marxist who just ignores what someone says and puts words into their mouth, Tracy. But I'll let my moderators deal with you if they think that you're offering anything valuable to the conversation other than a stupid comment like that. I'll allow them to have you stay in the chat. But let's get back into the arguments where your Democrat justice appears to be arguing that racist laws should apply. And I'm just curious as to why you're not against that. It makes me a little sick to my stomach. Let's go.
And opens it to the public, has consented for people to come in. So it really is a function of property law and the extent to which the consent is being implied or, expressed, and the state law governing that, right? I mean, you don't have a right to go into private property. You're only there because the owner has either implicitly or expressly consented.
You have a constitutional right to carry your firearm onto that Pacific gas station.
You do. Where is that? I thought the reason why this was all here and is because you had an implied license. I thought the historical tradition required you to have a license because you don't have a right to go onto private property, and the tradition was we're going to imply that you have a license under these circumstances.
The basis of this lawsuit is that we're only discussing private property where you have a right to enter onto that's open to the public, and we're saying that once that property is open to the public, we have a right to carry a firearm onto it.
Okay.
Unless the government.
Okay, I think I understand. Let me just ask you about the black codes. Justice Gorsuch raised it, and I guess what I'm wondering, your answer to him was they can't be and shouldn't be used, and I guess I'm wondering whether that doesn't signal a problem with the Bruen test, that to the extent that we have a test that relates to historical regulation, but all of the history of regulation is not taken into account, I think there might be something wrong with the test. So can you speak to that?
There's nothing wrong with the Bruen test, Your Honor. Just on a fundamental level, the black codes can't be used because they dealt to discriminate against a small.
No, I understand why you're saying they can't be used, but it's because.
So there she goes. So if you hear her arguments, she's like saying, well, why shouldn't a racist law that discriminated against black people apply here? Again, it was a military admiralty maritime law that was issued basically fiat without legislative authority to prevent newly freed slaves from keeping and bearing arms. And you have a black Supreme Court justice saying, well, why shouldn't they apply? Well, first of all, it wasn't even a law. Second of all, the Constitution prohibits discrimination against black people. Why would she even ask this question? I posit for the audience here in my show. Why would she even ask this question, guys? I want you to think about that, especially people who consider themselves to be Democrats. Why is that okay? It's not okay, guys. It is not okay.
We've moved away from that history, not because that history didn't exist. And so to the extent that the test today is tying us to historical circumstances, it would seem to me that all of history should be on the table. And if we start taking pieces off, whether it's because we've moved away from it or we don't agree with it anymore, I think there's going to be a problem with respect to the accuracy of our test.
Your Honor, it's not just because we don't agree with it anymore. It's that the 1865 law is not relevantly similar because it dealt with a very small segment of society that was being discriminated against, whereas here, law is a law of general applicability.
That's right.
So the two
to people other than the people in this small segment that you're talking about.
Okay, so just really quick, I can't let this go. So we have Tracy saying both side wants your guns. I think you meant to say want your guns. Obviously, you're Harvard educated, so you don't know how to spell. But with respect to that argument, guys, we have Trump's Department of Justice arguing alongside of my attorney, Alan Beck, in favor of the people of the state of Hawaii to keep and bear arms, conceal carry on private property open to the public. So, Tracy, that argument doesn't pass any kind of judicial muster. I know you want to argue that both sides are the same, but the last time I checked, people who vote Republican know the biological difference between a man and a woman, and most of us who support the Second Amendment would never vote for a Democrat because we know that the Democrats want to confiscate our firearms. So, guys, give me a bunch of ones if you agree that most people who vote Republican believe that the Republican platform stands for the proposition that free people have the right to keep and bear arms, and that give me a bunch of, if you believe that, and give me a bunch of twos if you think that both parties are the same and they have zero difference in the way they approach the Second Amendment. I want to know what my audience thinks, not what a Marxist commenter who clearly supports the left, who says that she doesn't support either side, has to say. Anyways, let's get back into the arguments. It's very interesting.
Who were a part of society, but I guess you're saying that for the purpose of this test, we're not going to consider what happened to them.
No, what I'm saying is that the black codes dealt with a very. It wasn't a law of general applicability. It was designed to discriminate against. It was a racist law designed to discriminate against African Americans. Whereas here, the law at issue here is a law that applies to everyone. We can't use a racist discriminatory law to justify a modern day law that applies to the general public, Your Honor.
Thank you.
That's a rating.
Thank you, counsel.
Thank you, Chief Justice.
Ms. Harris?
Mr. Chief Justice, and may it please the court.
Okay, so now this is Miss Harris. So when we talk about Tracy, Tracy says there's no difference between the positions of people who vote left or right. But here we have now the lawyer for the Department of Justice arguing in favor of the Second Amendment, which we all know wouldn't have happened if Sleepy Joe, Dementia Joe, or Kamala Harris would have been elected president. They would have had some far left, anti-American lawyer arguing that no, the racist law should apply, even though it wasn't a law of general applicability. So let me explain what that means. A law of general applicability means a law that was duly passed by the legislatures or a state legislature, a law of general applicability that applied to everyone. And this was an ordinance passed by a racist union general, not a law that was passed by any legislature, to prevent newly freed black people from having firearms. And Justice Jackson just cannot, in any way, shape, or form, argue that that is a law of general applicability that will have applied to everyone. And this is Barack Obama's private attorney hired by the state of Hawaii. This is his best argument, that racist black codes should apply to keep the people of Hawaii from being able to keep and bear arms on private property open to the public. Good seeing you, RWS Stubbs. You're right. Everyone has a right to free speech, Tracy. So you should ask Joe Biden why he used the FBI and the CIA to ban people's social media accounts on Facebook and on Twitter using state action, who even mentioned the Hunter Biden laptop, using state action to prevent you from free speech. So you should ask them that, Tracy. Really interesting, the hypocrisy of the left on this channel. Let's keep going.
Bruen held that states can't refuse to license public carry. Hawaii can't gut Bruen by presumptively banning everyone licensed to carry from doing so at retail establishments or other private property open to the public absent the owner's express consent. That novel law offends our history and tradition. First, pretextual restrictions are by definition unconstitutional in why they regulate. Here, the law's text belies Hawaii's claim to protect property rights. Hawaii subjects just one right, the Second Amendment, and one class of people, the people Hawaii had a license to carry after Bruen, to its presumptive ban. Hawaii lets everyone else, including target shooters and hunters, bring firearms, machetes, and other things absent the owner's objection. Second, pretext aside, Hawaii can show no tradition behind its law. Its best analog is an unconstitutional black code. That's because, from the founding, the tradition has been that opening property to the public authorizes carrying. I welcome the court's questions.
What's your best support for what appears to be your argument that a pretextual regulation is per se unconstitutional?
I would start historically with Blackstone and the meaning of the word infringed in the text of the Second Amendment. If you look to Blackstone, which is one of the main sources underpinning what the pre-existing Second Amendment right meant, the canonical example of a law that burdened impermissibly the right to bear arms was the English game laws, which under the pretext of trying to preserve game were designed to prevent commoners from hunting. And we know that was one of the animating premises of the Second Amendment from
That's right. So, guys, we've been live for 2 hours and 30 minutes. I want to see if we've got Heller with us still. Hey, Dick, how's your comms doing, brother?
I'm still here. Unmute me.
Man, I can't hear you. So we got to figure out a way to get your comms working, because I want to get into part 2 with you next time. So what I'm going to do, Dick, is you and I are going to do a couple of shows together without an audience to try to figure out what's going on with your audio, because right now nobody can hear you, but we can hear the feedback of my voice feeding through your phone. So they're basically hearing me talk twice. But everybody, we're going to get ready to close the show out. And what I wanted to do is simply say, thank you, God, for Dick Heller. And he's up in the upper right corner there with those microphones. That District of Columbia versus Heller was passed, and now we have my attorney, Alan Beck, arguing before the U.S. Supreme Court with an ex-Democrat, I think he's still a Democrat, Donald Trump's Department of Justice, joining us in amicus, arguing alongside of us in favor of the Second Amendment. And I don't believe in throwing out the baby with the bathwater, R.W. Stubbs and Wanda Mise, or Mice or Mise. I believe that, we take them as we get them. Again, I'm not a Donald Trump quote unquote supporter, but I do support many of his policies, especially protecting our borders from foreign invasion. Give me a bunch of ones if you support that as well. And I don't believe that you have to support Donald Trump in order to support a lot of the things that he supports, including the Second Amendment. And whether he's disingenuous about it or not is irrelevant to me. What is relevant is we have Donald Trump's Department of Justice arguing alongside Alan Beck in favor of Dick Heller, in favor of the Second Amendment, to make sure that the people of the state of Hawaii's rights are protected so they can defend their home and hearth against, in part, a lot of the illegal aliens that Joe Biden flooded our country with so he could redistrict the country blue using the United States Census. That's the only reason they're here. That's why they got free stuff and went to sanctuary cities, because they knew if they went to sanctuary cities that Newsom would help deport them. And in return, using the United States Census, they're going to be able to create 3 or 4 new Democrat congressional districts. Instead of winning by vote, now the Democrats get several new congressional districts just with illegal alien body count alone. So, don't throw out the baby with the bathwater, guys. We have the Department of Justice arguing alongside we the people in favor of the Second Amendment and trying to be like a mom trying to distract her child with a redirect. I'm not going to fall for that argument. You don't have to support ICE in order to support protecting our borders. You don't have to support ICE in order to protect your wife and children against illegal alien criminals that have no reason and no right to be in our country. If they want to come here, they can come here legally, and they can swear an oath to uphold the Constitution. Give me a bunch of ones if you agree. And so don't fall for the CNN narrative. Don't fall for the narrative that's been adapted by many of the cop watcher community, unfortunately, directly from George Soros and CNN. You can support the Constitution and you can support we the people without supporting Donald Trump. And thank God that we finally have a Department of Justice. So I'll take my victories as I can get them. And I'll do some shows later about the Epstein and stuff like that, because look, if he has anything to do with Epstein Island or Pizzagate or any of this stuff, I want to know about it. But again, Donald Trump is a Democrat. He basically governs like a traditional conservative Democrat, like a Kennedy Democrat. The problem is the modern day Democrats are far left Marxists who burn American flags, at least in many of the so-called protests that are really just insurrectionist riots. Well, they're burning American flags. And I think that immigrants are great. But I don't think that the land was stolen by fraud or force. I don't buy the Marxist argument that it's stolen land or any of that. If that was the case, we'd have to go back thousands of years, because every piece of land in every country at one time or another involved a war where one party was defeated and the other party lost. And even with the natives in America, they were roaming nomads. They really had no land. They didn't even believe in property rights, and they would just kill each other and take each other's land. In fact, the Spanish conquistadors were only, maybe 500 men, and they basically allied themselves with the other tribes who hated the Aztecs, for example, to defeat the Aztecs because they didn't like them, and they took that land from the Aztecs. So, and by the way, the Treaty of Hidalgo that Mexico signed with America, we paid Mexico for California, Texas, Utah, Colorado, and I think a couple other states, if I'm not mistaken. And that's what happened. We paid them for it. And whether or not a treaty was ratified or satisfied, Wanda, I agree that there have been a lot of injustices over time. But again, we are the United States of America. We are not tribal land. And under the law of war, we won. And we now have the United States. So if you believe that you live on stolen land, please let me know what local Indian tribes are next to you, and I will represent those tribes pro bono to have you evicted and removed from the land that you live on. Since you think that you live on stolen land, I will volunteer my time to have you removed from that land and sent back to whatever country you think you belong to. But anyways, with that being said, guys, I hope you enjoyed part 1 of the show. I want you to thank Dick Heller for joining the show today. And I want you to thank Orange Man for doing something good, which is having the DOJ help the people of Hawaii get their Second Amendment rights restored. And Lynn Davidson, good seeing you, brother. And by the way, guys, Lynn, go ahead and throw your link up. I've been trying to help Lynn Davidson. He's a fellow brother. I don't believe in forced charity like the left does. I believe that if you want to help someone in need, that you form a parallel system and you help them. Forcing other people to support your charitable cause is nothing more than Marxism, and it's illegal. I believe that you should support people and the causes that you believe in because out of the goodness of your heart. And so I did a 1/10 ounce gold giveaway. It's about $700 worth of gold. And whoever the highest donor was to Lynn, and Lynn, I don't know how much we raised for you. Can you type that in for us, please, before we go? Because look, I'm not getting anything out of it. I got a couple of super chats. Do you think that's going to support my family? Of course not. I do these things because I care about people. And I genuinely care about people who believe in natural law and individual rights. And so, and Dick, you don't know about my 1/10 ounce gold giveaway, Dick. And I wish we could hear you, but we'll figure that out later. But I've got Dick Heller here in the chat with me. I did this because I'm trying to be an example to you guys and teach you about constitutional currency and all that other good stuff. And Wanda, of course, no disrespect intended. I don't expect everyone on my show to think like me or act like me. The reason why I do these shows is precisely because I believe in the constitutional republic. All right. And what that means is that the rights of the individual are more important than the rights of the mob. I don't support Marxism. I don't believe that the majority should be able to decide the rights of the minority. I don't believe in collective rights. I believe in individual rights. And you don't have to support Trump or not support Trump to be on my channel. And I love you, Wanda. And I know you've been on my show a lot. And I know you disagree with me a lot. But I'm not going to sit here and try to say that you're wrong or insult you to the degree that it's a personal attack. I disagree with you philosophically on many issues, but on many issues, I agree with you wholeheartedly with. And that's why I don't support the political party system. Because if everybody agreed with everyone and there's just two parties, there's no more individual rights. There are just a bunch of mind-numb robots. And we don't want that, guys. So give me a bunch of ones for Wanda Mise, for supporting the channel. And Wanda, if I'm not mistaken, you're one of my moderators. And if not, I'll add you as one. I think you had a different handle before. And yeah, you believe in individualism, and so do I. And Smokey says Japan did invade Hawaii. Let me see here. And Tracy, look, I get it that you want to make this all about Felon 47 and all that, but you should be thrilled that Trump is standing up for black people in that he's not supporting the racist black laws for the fundamental proposition that the people of the state of Hawaii shouldn't be able to keep and bear arms. I mean, that should be a given. And you shouldn't have to be a Trump supporter to support individual rights and freedom. And that's what makes me really sad about these Marxist-run teachers unions brainwashing all these kids to hate the Constitution under the guise that Trump is a bad person. That's stupid. So, guys, with that being said, again, thank you, Dick. And I'll just see if there's any other questions. I want to thank you guys all for the super chats and for supporting the channel and for buying paid subscriptions, helping me rebuild the channel after our ban by CommuTube. And now I'm back. And unfortunately, I've got a back injury, so I haven't been able to go live that much. But I've been doing my best. Thank you, Pro Se America, for coming on the show today. I know all about your email and your description and all that. And at some point, I will do a show with you where you can talk about your case. As it is, I'm on a ton of painkillers just to be able to do this show. And after I'm done here, I'm going to take a nap. And then I've got to work on some briefs. I've got some cases on Tuesday, some hearings. So again, I am a practicing attorney. I've been practicing law for a little over 20 years. I want to thank Life Under the Microscope for helping Lynn Davidson. And yeah, nobody can hear Dick. Dick, can you scream over the? real quick and say goodbye to everyone?
Thank you.
Thanks, Dick. And Dick, I'll reach out to you later after I take my nap, and we'll try to get your comms worked out, all right?
Roger that.
God bless you, Dick. And guys, with that being said, make sure, and give me a bunch of ones for Tracy's contribution to the discussion, even though it was completely off point and had nothing to do with the Second Amendment. But just that she had the bravery to show up here. And also, I forgive all you guys who think that just because I support legal immigration and I support having a safe border that's protected and not giving free handouts to illegal aliens, I forgive all of you for thinking that means that I'm a Trump supporter. I am someone who supports individual rights. And I've got a lot of bad things to say about Trump. But the issue is, guys, is I'm not here to talk about the bad things. I'm here today to talk about the Second Amendment, individual rights and freedom for the people of Hawaii. And fortunately, Trump supported us on this issue. And so the enemy of my enemy is my friend. Art of War, Sun Tzu. And thank you, R.W. Stubbs. And everybody's praying for me to get better. And I think it is going to help. But I just want to say, everybody, God bless all of you for coming to the show and having the knowledge and understanding that you don't have to be a far right or a far left person to support the Constitution and the Bill of Rights. You just have to be a God-fearing American who believes in natural law, that our rights come from an all-powerful creator, not the government. Anybody who thinks that your rights come from the government is your enemy. And with that being said, guys, make sure to like and subscribe. Thank you, Jody Shiloh, for showing up and always supporting the channel and the God-fearing wing of the Cop Watcher community. Make sure to like and subscribe. Make sure to save, because we never know when the thought police are going to take down this channel. Semper Fi.